Delivery order items were one.
For reasons mentioned in the order, the petitioner Azimuddin is allowed to go on bail of rupees 50,000 with two sureties of like amount with certain conditions.
May I beg to mention for listing of a matter tomorrow, Lordship. One matter is already listed tomorrow, and that is in connection with the arising out of same affair.
Listed before this court.
Lordship.
Okay.
Taking my lord indulgence to mention item 41, with the consent of both the parties, may the matter be taken up at 2 p.m. My lord, this is the part heard matter.
At 2, we have a PC, or we can take it up at 3.
Please. I think 1 hour is sufficient time to conclusively finish the matter.
You need 1 hour.
I will take around 30-40 minutes.
Then we'll take it up at 4. We have 45 minutes left.
No, my lord will, because then.
No, we have other matters to complete.
Because then it will also be this taken up for rebuttal arguments. That is the reason. If I take around 30-40 minutes, then the learned senior colleague will take another 30 minutes, I believe, to conclusively finish the matter today.
No, you finish your part, because we will not be able to complete the regular bail matters.
Please,
At 4, we will take it up.
at 4. Please.
May I please, Your Lordship? Lordship, I beg to mention for listing of a bail application for tomorrow, Lordship. Lordship, as per the fire Lordship, it is below 7, and as per Roster Lordship, and 2 of the co-accused Lordship has already protected Lordship. Lordship may kindly pick up this matter on tomorrow, Lordship.
When have you filed?
Lordship, yesterday, Lordship.
Okay.
Give Lordship.
May I also give? Regarding item number 9, my lord, I have filed an affidavit reply, my lord. That will be called for, my lord, understanding.
Item number 9, additional affidavit.
I beg to mention 35, my lord. I think CD is not there, my lord, after vacation.
Item number 35.
35.
Heard Mr.
SS Shikdar.
S. What is your name?
SS Shikdar, my lord.
S.S. Sigdar. You are not
My lord, on behalf of JLE, my lord.
S.S. Sigdar submitting on behalf of JLE. Also heard,
Interim is there, my lord, diary not received.
also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on 22nd of July. The interim order shall continue till next day.
Obliged.
May I please, your lordship?
Yes.
Please, your lordship. Lordship, with regards to item number 47, my lord, hearing matter, my lord. This matter should go to the appropriate division bench, my lord, as per the order passed in this 24/8/22, my lord, because it is a XMLA, my lord.
Okay.
I think.
Heard
47.
Mr. What is
PK
the-
Bordle, my lord.
Heard Mr. P.K. Bordole, learned counsel for the petitioner, who submits that this matter is in connection with a case involving ex-MLAs.
My lord, as per the Supreme Court.
It should be
Ashwin
listed
Kumar
before
Upadhyay versus Union of India.
appropriate division bench.
Okay, division bench.
Regist-
Interim order is there.
Stop. The registry to list the matter before appropriate bench. The interim order shall continue till next day.
May it please your lordship. Lordship, I beg to mention item number 16. My lord, it's a 439 application, however.
1-6.
My lord, 1-6, my lord. 1-6, my lord. My lord, it's reflected that the LCR is there, but however, up to date LCR was called for on the previous date, my lord. On 7-6, I've checked the office note, my lord, that LCR has not arrived, my lord. However, requisition is already sent as per the office note. So we'll wait for a week, my lord. I've been behind for 700 days. Next week, any date as per lordship's convenience. Regular bail application.
Heard Mr. D.K. Bodjo, learned counsel for the petitioner, who submits that the From records, it appears that the up-to-date
LCR, my
case record of the trial court has not yet been received. Hence, matter may be taken up after receipt of the up-to-date case record.
lord, next week, my lord.
Regis-
29.
Issue reminder for an up-to-date LCR. Up-to-date case record of the trial court, registry to take steps. Let this matter be listed.
26, 27, 28,
28,
27, if it's possible, my lord.
27, okay.
27. Deeply obliged, my lord. Deeply obliged.
26, Mr. Boddo.
26.
Six.
6. Obliged.
Wait. I beg to mention, Lordship, item number 40. Lordship, said that the case there is not available.
40.
40, Lord.
Heard Mr.
H. Agarwal.
H. Agarwal, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary.
Interim assignment.
The prayer is allowed. When will you produce?
Interim is there, my lord, after petition.
Let this case be listed again on 22nd of July. The interim order shall continue till next day.
Like,
May I please, Lordship? Lordship, item number 6, Lordship. Lordship, we, at the time of filing, we have done some mistake, Lordship. Inadvertently, annexure 1, Lordship, 1 page is misplaced, Lordship. So we may be allowed to insert the page, Lordship, before the registry, Lordship.
You file an additional
Yes, Lordship. Additional evidence.
additional affidavit by way of an additional affidavit.
Yes, Lordship. Item number 6.
So this matter can be taken up today itself, or
No, Lordship, on Monday, Lordship.
heard Mr. What is his name?
D. Sutia, Lordship.
Heard Mr. D. Chutia, learned
For the
counsel for the petitioner, who submits that due to inadvertence, the petitioner could not insert some relevant documents in the criminal petition filed by him, and hence prays for filing an additional affidavit. The prayer is allowed. Let this matter be listed again on, when do you want?
Monday, Lordship.
24,
6,
2026, 24.
highly obliged.
My lord, I'm praying for the urgent listing of an anticipatory bail on tomorrow.
Matter relates to what?
Matter relates, the petitioner is a government servant.
What is the offense?
Section.
Next.
Because there are senior courts you have to mention before.
If the punishment is less than 7 years.
Less than 7 years. You're sure? You find it out and mention again at 2.
As instructed by my senior. I was asked.
Section 2 na jano.
Section 2 jano.
You find out the sections and then mention again. Yes, next mention. Yes, if time permits.
Me, please, your lordship. Lordship, I beg to mention for the listing of an IA. It was filed for the modification of a bail order passed by your lordship regarding the IDs.
When do you want?
Tomorrow, lordship.
Okay.
Bless.
May I please, your lordship? Also, beg to mention item number 30, LCR not received.
30.
Item number 30. You have gone through the office note.
Yes.
Heard Mr. What is your name?
Exit Mena. A Mena.
Heard Mr. A. Mena, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. From the office note appended in the case record, it appears that the scanned copy of the trial court record, which was called for, has not arrived. Scan copy was called for.
Yes.
Issue reminder for the same. Let this matter be listed again on after reopening. On 23rd July. Yes,
The sections are 420, 406, 385, and 387.
okay,
Can it be listed
Hello.
tomorrow?
okay.
Much please.
May it please the Lordship. Lordship, the declaration item number 22. In this matter, my lord, LCR has not been received. The registry, my lord.
22.
22, man.
You have gone through the case record.
Yes, man, it is not there, man.
Heard Mr. M.A. Chaudhary. Also heard Mr. B.B. Gogoi, learned counsel, learned additional public prosecutor. From the office note appended in the case record, it appears that the trial court record, which was scanned copy of the trial court record, which was called for, has not yet arrived. Issue reminder for the same. Registry to take steps. Let this case be listed again on 21 July
20,
22.
man.
Is it okay?
24, my lord.
24 July.
Deep level.
May I please, Lordship? Lordship, I beg to mention item number 32. City not in city.
32.
Yes, Lord. I am an interim.
Heard Mr. A.T. Sarkar, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. When will you produce?
After vacation, interim is there.
Let this case be listed again on 23rd, 24th July for case diary. The interim order shall continue till next week.
May I please, Your Lordship? For 39 application, my lord. FIR is on page 10. 24 days behind the bar as on today, madam. Operative person is page 12.
Case diary would be required.
My lord.
Case diary would be required. Heard Mr.
M. Rahman.
M. Rahman, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. When will you produce?
28 before vacation, we try.
List this matter on 28th of June
All
for
right.
case diary.
So this division is directed against the judgment dated 4/9/2018, whereby the petitioners has been convicted under section 498A and sentenced for 1 year imprisonment. And the order dated 6/5/2024 passed by the appellate, confirming the conviction. Trial court judgment at page 35.
Where are you now? You are behind the bars.
Yes, Lordship. What happened immediately after pronouncing the judgment, the counsel, the counsel for the petitioner forget to file an application for allowing him to remain on previous bail. So therefore, immediately after the judgment, they has been arrested and put behind a bar. So therefore, we have filed an IL also.
Okay, you take steps for issuance of notice to the
And we may be allowed to.
after hearing the other side.
Also, there are several inconsistencies. We have the
But
entire record.
this is revision after appeal, after it has been
That is
confirmed
there
in.
also. I am going to the learned court below convicted the petitioners wholly relying on the person of the PW1 and the PW.
No, I'm not on that.
Yes,
Your original conviction has been upheld in the appeal.
yes,
You are in revision against the appellate orders.
yes.
Therefore, before granting any stay, I deem it proper to hear the other side. That is the only. I'm not saying that you
Because-
will not get.
We are behind the bar, Lordship. So we may be allowed to go on bail, Lordship.
You are behind the bar because
Because on the 6th fair judgment has been pronounced and we have been
6-5.
arrested on 31-5.
you take steps.
But only 1 year, Lordship, conviction, Lordship.
I'll give a fixed date. On the next date, if you take steps and service is complete, even if.
Service is will not complete because the Lordship stated that, Lordship, prior to lodging this FIR, the informant has lodged another FIR.
No, why service will not complete?
Because I'm stating that because in that case, he is not appearing. Because there are two proceedings under the 498A.
No, appearance is not necessary.
Yes,
Even if service is complete from your side,
yes.
your interim will be considered. That assurance, that I will reflect in the order sheet.
কোর্ট আছে এটা মানুষজনই কোর্ট আছে এটা অ্যাড্রেস নাই unnecessary procedural
A bailable warrant has been issued against the informant, Lordship, in another proceeding. Prior to lodging this FIR, she has lost.
We are not concerned about other cases.
Yes. Such only 1 year conviction. The interim bail may be given,
We are
Lordship.
giving a short date.
Lordship, interim protection may be given on the next day. Lordship will decide whether that the judgment will be stayed or not.
On next date, I will decide whether it will be stayed or not. That is the interim protection.
Only 1 year conviction, Lordship.
Heard,
And
heard Mr. S. Deka, learned counsel for the
কিন্তু বাহিৰত থাকিলে তো
petitioner.
প্ৰব্লেম নাছিল
Also heard Mr. B. Gogoi,
উকিলৰ ভুলৰ কাৰণে হৈছে
learned additional public
ফিজ
prosecutor.
দিয়া নাই ফিজ দিয়া নাই
This application under section 397/401 read with section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner. Both of them are behind the bars.
yes, Lordship. The two is the sister-in-law and one is the husband, Lordship. That is the difficulty. She is a widow, Lordship. So therefore, I am pressing, Lordship, they may be allowed to go on bail.
You take steps.
বিফোৰ ভেকেশ্যন ডেট লৈ ফৰ্মেলিটিটো অবজাৰ্ভ কৰিব লাগিব
I will take the step, Lordship, today itself, Lordship, before vacation, Madam will fix it.
Okay. How will you take steps? Through
ৰেজিষ্টাৰ
Register step, Lordship.
then you have to submit the tracking.
Yes. Trustee is also not possible because in another proceeding, warrant has been against her. She is not appearing before the court. We have annexed that order also. Page 22, Lordship.
What is your ground?
Here ground is that whatever she stated in the FIR and 160th statement, that apart from that, there are more story which has been,
Where the first appellate court erred? What is the error of the first appellate court in upholding the judgment of the trial court?
the trial court has convicted solely relying the version of PW1
Okay,
victim and the 2, 3, 4, they are the Mohila committee, president and secretary.
okay.
In the evidence, whatever she stated, that has neither been stated in her FIR nor in the 160th statement. And the such fact has been corroborated by the IU in his statement that whatever she has deposed before the court, she has never stated before him. So I have the evidence, the entire
Okay.
evidence is done.
That is, no, I'm not going into evidence now.
Yes,
Because in revision against appeal,
yes,
we cannot go into many other questions.
Yes.
There are limitations in,
yes,
this is the second forum.
yes.
These questions could have been raised before the first appellate court.
That was raised, Lordship.
Then why first appellate court was not
But
convinced?
appellate court is, the judgment has not discussed about that aspect, Lordship. The finding is that,
Because in the revision, you have to first convince that the first appellate court committed error.
yes, Lordship.
Then you have to go to the,
Page 61, Lordship. Finding of the appellate court, Lordship. Lordship, got it. Page 61,
Yes.
paragraph 18. May I read it?
Yeah, notice
Big sets. Big sets যদি move না করছে,
petitioners impugning the judgment dated 6/5/2024 passed by learned additional session judge Golaghat in criminal appeal number 55/18, upholding the conviction and sentence of the petitioners under section 498A IPC imposed on them by the Court of Learned Judicial Magistrate First Class Golaghat in GR case number 1389/2016 by the judgment dated 4/9/2008, whereby the petitioners were sentenced to undergo simple imprisonment for 1 year and to pay a fine of rupees 1,000, and in default of payment of fine to undergo simple imprisonment for 1 month. Call for the case records of GR case number 1389/2016 from the Court of Learned Judicial Magistrate First Class Golaghat, as well as the case record of criminal appeal number 55/2018 from the Court of Learned Additional Session Judge Golaghat, registry to take steps for requisitioning the aforesaid case records. Also issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As against respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with AD within 2 days from the date of this order, returnable on 28th of June 2024. The prayer for interim relief regarding suspension of the sentence imposed on the petitioners during the pendency of the instant criminal revision petition would be considered on the next date after due completion of service on the respondent number 2.
And on for bail, Lordship.
List accordingly. This IA is for,
Highest for bail, Lordship.
in view of the order passed in the criminal revision petition number 231/2024, list this IA along with the said case on 28/6/2024.
Publish.
Please, your Lordship. Lordship, the 482 application for quashing of a proceeding under section 138 of the Negotiable Instruments Act. Now, the case in question is covered by 3 principles of settled law, my lord. My lord, the first issue is when a complaint is filed against the director of a company in respect of a check which is issued on behalf of the company without including the company as a party, company as an accused, my lord, that complaint is not maintainable. My lord will kindly come to page 17.
Yes.
Page 17 is the complaint, my lord, which has been filed by Dr. Divyajyoti Kolita, complainant, accuses Sri Rohit Saikia. Now, my lord will kindly come to page 18. Page 18, my lord. Second paragraph, my lord. The complainant begs to submit that accused being the director of Nephrocraft Private Limited engaged the complainant Dr. Divyajyoti Kolita for professional medical service in the healthcare and hospital establishment Renofresh Dibrugarh in the year 2022. Accordingly, the accused executed an agreement with the complainant and the complainant started providing medical services under the above stated establishment of the accused. Well, the agreement which was executed was between Nephrocraft Private Limited and the complainant, my lord.
Where is the
The
agreement?
agreement is, my lord, at page 37. These are their documents, my lord, relied upon by them, my lord. Page 37 is the agreement, my lord. Relevant part, my lord, will find it page 38.
Okay.
It is executed between Nephrocraft Private Limited, represented by its director Rohit Saikia, and the complainant. Now, my lord, may kindly come to page 44. Page 44 is the check, my lord. My lord will see this check has been issued for Nephrocraft Private Limited. Authorized signatory is Rohit Saikia, director. There's another director, he has also not been made an accused, my lord.
The company has not been made an accused.
Company has
That
not
is
been
our
made an accused.
grievance. The check was issued in the name of
The company by its authorized signatory, who also happens to be the director.
Oh.
My lord,
on behalf of the company, the directors. Okay.
director has been there, my lord. No, my lord, I'm relying on three judgments of the Honorable Supreme Court on this point, my lord.
Have you appeared?
No, not yet, my lord.
Summons have been issued.
Summons have been issued, bailable warrant has been issued. There is also another issue, summons was not served, but bailable warrant was issued. But apart from this issue also, my lord, there are two more other issues, my lord. Will kindly come to the cognizance order at page 52.
Yes.
Page 52, madam. Complainant is present. Complainant has submitted the original documents which are marked as exhibits and kept with the record. After perusing the case record, following facts are brought into the right. Date of issuance, date of so and so, so and so. Then as the accused person has failed to make the payment within 15 days of receipt of the notice, as such cause of action arose after the expiry of the said period of 15 days. The complaint was filed on such and such, which is within the period of limitation. Peruse the case record, which includes complaint, initial deposition on affidavit, and relied upon documents. Upon perusal of the aforesaid materials, it appears that there are sufficient grounds to proceed against the accused person, Sri Rohit Saikia. So the cognizance has been taken against the director under section 138 of the Negotiable Instruments Act. So, my lord, this is a case where the accused is residing in Guwahati. The case has been filed in Dibrugarh. So, since the accused is residing beyond the territorial jurisdiction of the learned trial court, compliance of section 202 CRPC was mandatory in this case. So, there was some dispute on this issue as to whether 202 CRPC is applicable in NIA cases or not. Subsequently, a constitution bench of the Honorable Supreme Court has made it clear, and I'll provide the judgment, my lord, that 202 CRPC has to be done even in an NIA proceeding. The only leeway which has been given is that oral examination of the witnesses need not be necessary. Their evidence may be taken on affidavit also, my lord. So that is the second ground on which, my lord, the learned trial court has faltered, my lord. And thirdly, my lord, under the scheme of the Negotiable Instruments Act, my lord, once the check is dishonored, the payee of the check or the holder in due course has to issue a notice, demand notice. After the service of the demand notice, the drawer of the check gets a time of 15 days to repay the check amount. If that amount is not paid within 15 days, then the cause of action for filing the complaint arises. Here in this case, my lord will kindly see the demand notice, which is at page 50, my lord.
Page 50.
Page 50, my lord.
Yes.
This demand notice was issued on 6/3/2024. And as per the tracking report which has been submitted, which is at page 48, it was delivered on 11/3/2024.
So the period will start computing from
After Exactly
11
15 days from 15 days after 11. So it will rise from
after
26
11 or after 6?
No, 15 days from the date of service of notice, my lord. So
Okay.
notice was served on 11/3. So it will, the cause of action will arise from 26. Now, my lord will kindly turn to page 55, and my lord will find the relevant part at page 56. My lord will find the 1, 2, 3, 4th entry, my lord. 19/3/2024. I have already repaid the check amount, my lord. Exactly the same amount, 3,39,065 rupees and 25 paise through RTGS. So I received the notice notice was served on 11/3. On 19/3, which is within
okay.
8 days, my lord.
Before your submission is before the lapse of the period
15
of
day
the
period.
15 days after receipt of demand
Which
notice,
we have paid the check.
you have paid.
So cause of action never arose. The offense never got completed, my lord.
What was the amount?
3,39,068 rupees and 65 rupees and 25 paise.
Where at page 55 it's
My
appears?
lord, page 56, my lord. 4th entry, my lord. On 19/3/2024, we have paid this amount.
333,552.
Yes,
Okay.
lord. Up to the last 25 paise, my lord, we have paid. So in this case, my lord, it is my humble submission that first of all, the complaint itself is not maintainable because they have not made the company a party. Secondly, the London Trial Court did not conduct an inquiry under 202 CRPC, which is mandatory when the accused resides beyond the territorial jurisdiction of the court.
Where is the constitution?
My lord,
Where is the judgment of the constitution bench? Heard Mr. S. Nawaz, counsel for the petitioner. State is a party.
state is a party.
Also heard Mr. B.B. Gogoi, learned additional procedural secretary. This criminal petition has been registered on filing of an application under section 482 of the Code of Criminal Procedure, 1973 by the petitioner, namely Rohit Saikia, praying for quashing of the criminal proceeding in NI Act, NI case number 74/2024, which is pending in the Court of Learned Judicial Magistrate First Class, Dibrugarh. It appears from record that the respondent number 2 had instituted, where is the complaint?
Complaint, my lord, is at page 17, my lord.
Had instituted a complaint case against the petitioner under section 138 of the NI Act, alleging dishonor of check issued by the petitioner on behalf of
Nephrocraft Private.
Nephrocraft Private Limited, and thereby committing the offense under section 138 of the NI Act. The said complaint case has been registered as NI case number 74C/2024, and cognizance of offense in the said case against the petitioner was taken
Page 52, ma'am.
by the learned magistrate after examination of the complainant, that is the respondent number 2, under section 200 on 1/4/2024. Learned and 1/4/2024, and summons were issued to the present petitioner by the said court. Learned counsel for the petitioner has assailed the taking of cognizance against him, against the petitioner by the learned judicial magistrate first class Dibrugarh in NI case number 74/2024 on mainly on 3 counts. Firstly, it is submitted that the check in question was issued by the company Nephrocraft Private Limited, of which the petitioner is only one of the directors. However, as the mandate of law requires, the company has not been made as an accused by the respondent number 2 in his complaint petition. Neither the co-directors have been made as accused. It is submitted by learned counsel.
No, it is, these are the judgments on.
It is submitted by learned counsel for the petitioner that as the respondent number 2 had an agreement with Nephrocraft Private Limited only, of which the present petitioner is a director. It was mandatory on the part of the respondent number 2 to make the said company as an accused in the NI, in the complaint filed by him under section 138 of the NI Act 1881. Learned counsel for the petitioner has also submitted that the learned judicial magistrate first class Dibrugarh took cognizance of the offense after examination of the complainant, that is respondent number 2, under section 200, and no inquiry or examination of witnesses as required under section 202 was conducted by the said magistrate. Though the present learned counsel for the petitioner has submitted that as the present petitioner is a resident of Guwahati, which is outside the jurisdiction of the court, taking cognizance under section 138 of the NI Act, it was mandatory on the part of the learned magistrate to follow the mandate of section 202 CRPC before issuing summons, before issuing processes to the present petitioner. Learned counsel for the petitioner has also cited a ruling of the apex court in the case of
In re expeditious trial of cases under section 138 of NI.
in the case of expeditious trial of cases under NI Act 1880, in re expeditious trial of cases under NI Act reported in 2021-16 SCC 116, where a constitution bench of the Supreme Court of India has
The relevant paras will be paras 10, 11, 10, starts from 10, my lord. And finally, my lord, the final finding is given at 24:2, my lord. Page 130.
24.
24.2, my lord, page 130. Second last paragraph.
where the apex court held that if the accused resides beyond the territorial jurisdiction of the court, even in the case of complaint under section 138 of the Negotiable Instrument Act, 1881, the inquiry under section 202 is mandatory. 202 of the CRPC is mandatory. Learned counsel for the petitioner has also submitted that in the instant case, the demand notice issued by the respondent number 2 was received by the petitioner,
And it was served on the petitioner.
was served on the petitioner's company
Address.
on 11/3/2024, and therefore, as per section 138 of the Negotiable Instrument Act, the cause of action would have arisen only after 15 days of the said date, that is on 26 or 26
Three, madam.
2024. However, it is submitted by the learned counsel for the petitioner that before lapse of the said date, that is on 19/3/2024, the petitioner's company had paid back the entire check amount to the account of the respondent,
In respondent number 2, madam.
respondent number 2. And in support of his submission, the account ledger, what is this?
My lord, this account ledger as provided by my own bank, my lord, by my banker.
Account ledger statement provided by the petitioner's bank has been furnished by the petitioner along with his criminal petition. Stop. Issue notice to the respondents. No, this has already been dictated. In view of above, till receipt of till next returnable date, the further proceeding of NI case number 74/2024 pending in the Court of Learned Judicial Magistrate First Class Dibrugarh is hereby stayed. List accordingly. Notice kimandi notice for 4 weeks. 4 weeks. After 4 weeks.
The next item is same between the same parties, same issues barring the last issue, my lord. First issue, my lord, remain company has not been made a party. 202 inquiry has not been done. Here also I have paid the amount, but the amount has been paid on the 29th day. But the first two issues remains the same, my lord.
Same party.
Same party, my lord. Same party. This is before the SDCM Naharpatiya, my lord. Complaint, my lord, at page 16.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This petition has been filed under section 482 of the Code of Criminal Procedure, 1973 by the petitioner Rohit Soikia, seeking quashing of the proceeding of NI case number 19/2024 pending in the Court of Learned Subdivisional Judicial Magistrate Naharkatia. The records, on perusal of the records, it appears that the respondent number 2 had filed a complaint case under section 138 of the NI Act against the petitioner in the Court of Learned Subdivisional Judicial Magistrate within bracket M Nahar Kotia, and on 1/4/2024 on the basis of 1/4/2024, after recording the statement of the respondent number 2 under section 200 of the Code of Criminal Procedure, Learned Subdivisional
Madam, sorry for the interruption, madam. Statement under 200 on affidavit. Madam.
statement of the respondent number 2, statement of the complainant / respondent number 2 on affidavit, Learned Subdivisional Judicial Magistrate within bracket M Nahar Kotia took cognizance of offense against the present petitioner under section 138 of the NI Act and has issued summons to the present petitioner. Learned counsel for the petitioner has assailed the order of the Learned Subdivisional Judicial Magistrate M Nahar Kotia, whereby he took cognizance against the present petitioner mainly on 3 counts. Firstly, the check in question was issued by the present petitioner only on behalf of the company of which
Page 36, madam. Nephrocraft Private.
of which he is the director, namely
Craft Private Limited.
Nephrocraft Private Limited. It is also submitted by learned counsel for the petitioner that the respondent number 2 had entered into an agreement, had executed a deed of agreement only with the company of the present petitioner, that is Nephrocraft Private Limited. It is submitted by learned counsel for the petitioner that as the check was issued by the Nephrocraft Private Limited for and on behalf of Nephrocraft Private Limited, the company ought to have been made an accused in the complaint case filed by the respondent number 2. Learned counsel for the petitioner has also submitted that though the petitioner hails from Guwahati and the court which took cognizance is situated at Naharkotia, and therefore the petitioner lives outside the jurisdiction of the said court, the procedure prescribed under section 202 of the Code of Criminal Procedure ought to have been followed by the Court of Learned SDGM M Naharkotia before issuing process against the present petitioner. And non-issuance of, would it be fatal?
Yes, madam. It's found to be held to be mandatory, madam. 202 as a.
And non-issuance of and said following of the said procedure is held to be mandatory in the case of expeditious trial of cases under section 138 of NI Act 1881. Reported in 2021 16 SCC 116, wherein the Apex Court of India has held that even in complaint case under section 138 of the NI Act, where the accused resides beyond the territorial jurisdiction of the court, the conduct of an inquiry under section 202 of the Code of Criminal Procedure, 1973 is mandatory. Learned counsel for the petitioner has also submitted that in the meanwhile, on 29/3/2024, the petitioner has already repaid
No,
back
on
the,
ten, in this case, we have 10-4.
on,
10-4.
not, on 10/4/2024, the petitioner has already repaid back the check amount to the respondent number 2. Stop. Issue notice to the respondent number 2. Issue notice to the respondents, since learned additional public prosecutor has appeared on behalf of respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 4 days from the date of this order, returnable after 4 weeks. However, stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, further proceeding of NI case number 19/2024 pending in the court of learned subdivisional judicial magistrate within bracket M. Nahar Kotia is hereby stayed. List accordingly.
No, there are bailable warrants of arrest pending in both cases, my lord. There may be reflected. Otherwise, I'll again have to appear to get that bailable warrant cancelled.
No, it is stayed. Whether
It has already been issued, my lord. So, though the proceedings are stayed, my lord, there's possibility that it may get executed, my lord. An observation, my lord.
in both the cases, the bailable warrant issued by the trial court shall also remain stayed until further orders.
I'm deeply obliged.
May it please your lordship. Lordship, this is a 438 bail application, lordship. FIR, lordship, will find on page 14, lordship. I am not for the accused number 1, I am for the accused number 6, lordship. 4, 5 and 7 of this FIR name accused already granted bail by the coordinate bench on motion, lordship, in interim protection. That is on page 22,
You are
lordship.
for accused number?
6, lordship.
What is the allegation?
Allegation, lordship, is that, lordship, against accused number 1, lordship, may I read the FIR, lordship? It is respectfully submitted that yesterday on 7/5/2024 at about 11 p.m. the accused number 1 eloped with my minor daughter Anjua Khatun, aged about 17 years 8 months, by inducing her. When the daughter went to his house, then rest of the accused person assaulted her and misbehaved with her by disrobing. Later, the VDP party of the Haballar Park village rescue my daughter, and from the hand of the accused person. It is pertinent to mention here that it was learned from my daughter that the accused.
Yes, Mr.
Yes,
Uddin.
my lord, lordship was asked me whether in absence of alternative remedy, 482 petition can be filed. I have filed the petition under section 482 CRPC against the discharge order. I made impugn. So on that day, my lordship was asked me whether I have to file revision on that matter. I have done some judgment matter. Some are in my favor and some against also matter. But one judgment, lordship, may kindly see paragraph 21, 22, 23.
But when the relief of revision is available to you,
Yes, ma'am.
you then, because in case of revision, question of limitations and other questions are there.
There, yes.
And when there is a specific provision in the code,
Lordship.
whether 482 can be exercised.
Yes, ma'am. My lord, in this judgment, we will discuss para number 21, 22, and 23. ma'am.
Yes, what is? Now, what do you propose? What you want
I
to
want-
pursue this?
Yes. Question.
Then we will issue notice and
Notice.
we will see at the time of
Right.
admission whether it can be admitted or not. Heard Mr. G. Uddin, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure 1973 has been filed by the petitioner, namely petitioners, namely Safiqul Islam and Parvina Khatun, praying for quashing of the proceeding of sessions. Next item. Yes.
Lordship, in this case, it was posted on 18+. So I have challenged the order passed in the DBA, in the DB case. It is an interim order of maintenance, and Lordship pointed out that there is a provision of appeal under section 29. And my submission was that I approached the appellate court, but my appeal was not registered. And
Lordship, as per office note dated 12/6/2024, service report is awaited, Lordship.
Service report on
Respondent number 2.
now what is to be done? Respondent number, this is a POCSO case.
Yes, Lordship.
Have you taken steps
Yes, Lordship.
up to date?
Status report from the trial court was called for lordship. Also, after filing this petition, lordship, Sasi has been filed on
Item
April
11.
9, 2023. But has not yet claimed lordship. Petitioner is a diverse handyman of the offending vehicle.
Scan copy has been received.
Lordship.
Now what is your submission?
Actually, the petitioner behind the bar for more than 451 days, lordship.
How many?
451 days.
451 days. It is an NDPS case.
Lordship.
What
It
is-
was called for lordship. The petitioner is a divine handyman, lordship. But has not yet claimed.
What is your ground?
Also, after
Oh.
five, they are the diver handyman, they have no knowledge that there is a secret chamber in the vehicle, lordship.
Mr. Sharma,
My lord.
go through the record. Is there any material against them? No other submission.
And then till then, lordship, trial is not started, lordship. It is also under ground, lordship. Then there is delay.
No, but 451 days delay is not sufficient delay.
It's too, lordship.
If you are only on the ground of delay of
So,
451,
and this petition has been filed, but I ordered the filing of the Sasi, lordship. I filed it on 1/9/2023, but Sasi has been filed on 15/9/2023.
no, you are behind the bars for how many months? 1 year?
Okay, one and above 451 days on date, lordship.
1
They
year,
are arrested on 26/3/2023. In the month of March 2023.
26,
2023.
Suspend one.
That's when I
3/20, 23.
26/3/2023.
1 year, 2 months,
1 year, 2 months.
2 months, some days. So your grounds are only prolonged incarceration, nothing else.
Lordship, because I filed this petition prior to filing of the charge sheet, Lordship. After this. filing of-
Maybe. But after. Then I will go through this and dispose of this case, because on prolonged incarceration, your case is not very strong case.
On the delay, Lordship, already coordinated as from mobile, Lordship.
How many days? How many days?
In this case, sorry, quite one minute. That case was in the petition arrest on 10/5/2023. And this petition was arrested on 26/3/2023. It is reported judgment, Lordship. Wherein, Lordship, the court relying upon that the husband of the Satendra Kumar Antin and the husband of Raghubi Singh, Lordship. There is delay and the right of.
No, we have dealt with lot of such cases where the accused persons are approaching the court in cases involving commercial quantity of contraband, where there is an embargo of section 37 on the ground of prolonged incarceration, long incarceration. But in almost all the cases, they have cited cases of apex court, where apex court also held that prolonged incarceration may be a ground.
This is also my ground.
But how long is prolonged? How
It is
long
not-
is,
It is not recorded.
so Supreme Court, the lowest period for which the Supreme Court has granted bail for prolonged incarceration, to my notice, is 1 year, 6 months, not less than that. So unless you have completed 1 year, 6
6
months,
months.
you will not.
After 1 month, after
vacation.
vacation.
What is your name? N.J. Gogoi. Heard Mr. N.J. Gogoi, learned counsel for the petitioners, who prays for listing this matter after summer vacations. The prayer is allowed. List this matter accordingly
Also fix a date after the.
after vacation. 25 July. I'm taking a short break.
Needed for that.
Do we have a video conferencing, PC matter?
Because LCR already available, Lordship is, there's nothing, Lordship, she is a major, but child marriage as well as POSCO will not come on the way, Lordship, she is a major, as per her statement 161 also there. And all,
Partnered matter is.
Lordship, partnered.
Human matter আছে।
Item to man?
8.
8.
Giving petition.
After that Nagaland matter. After that I will take. It will take half an hour.
Lordship,
You.
my
the
idea,
Nagaland matter would take half an hour,
Lordship, then after that, after 2, at 2, Lordship,
not at 2. At 2 now, I will take up the PC from Kohima. After it is over, I will take care.
Lordship. All 10-15 minutes will be required for that, nothing.
Yes.
So
you
this is
go
about-
first.
Yeah, appearance is a bus. Surgery frame hona.
No.
Yes, Mr.
My lord, in this matter, I was arrested on 16/10/2022, my lord. These two petitioners are the driver and the helper, my lord. Petitioner number 1 is the helper of the vehicle and 2
1610.
2022, my lord.
Okay. What is the period?
Period, it stands, my lord, 1 year, 8 months, 4 days.
Okay.
And 1613 days, my lord. The FIR is that, my lord, the vehicle was loaded by the owner, my lord, for carrying some rubber drums, my lord. And under the garb of rubber drums, they have loaded the vehicle with the contraband, my lord, which is the ganja. Page 8 is the FIR, madam, and relevant part lordship. will
FIR
find
is at page?
Page 8, madam. May I read from the last paragraph, madam?
Yes,
May I read from the last paragraph, madam, page 8?
yes.
I have sought authorization letter to search and seize the suspected ganja to CI Ramakrishna Nagar Police Circle, and I received the same at about 7:40 p.m. through WhatsApp message. At about 8:05, I started to unload the drums, which were filled with loaded liquid rubber, and checked thoroughly with the help of the Naka party in presence of independent witness. After unloaded all the drums, recovered total 96 number of packets of ganja recovered ganja from 48 numbers of empty drums. The suspected ganjas were also unloaded from the truck, with remaining 72 numbers of drums were filled with liquid. So, my lord, this vehicle was carrying liquid rubber, and for that, my lord, if I may take your lordship to the description of seizure, my lord. Page 9, my lord, lordship.
Yes.
Yes. Description of 9, my lord, serial number 3 and 4. They were provided with the duly invoice number at serial number 4, my lord, and e-way bill was also there. So my first submission is that I was not having any knowledge that the drums were loaded with the ganjas, my lord. Neither I was having any constructive or conscious possession. And secondly, second part of my submission is that, my lord, I have already undergone a period of 613 days. Considering this aspect, my lord, my bail term may be considered at this stage.
You are driver
Yes, my lord.
and
The petition number 1 is the helper, my lord. And another aspect, my lord, had there been any knowledge, my lord, they could have easily fled away before reaching the Naka.
now charge sheet has been laid against only both of you.
No, my lord, that person who the owner was, my lord, that loaded the goods, my lord. He was also been my lord, accused in this case.
Where is he?
He is absconding, my lord. NBW has been issued, my lord, as per the status report. He is absconding, my lord, and another trial court has already issued NBW. Charge sheet was 31/1/2020.
CS on 31,
31/1/2020.
20,
23, my lord.
and charges are not yet framed.
No, my lord, because of
Appearance test.
appearance stage, my lord. It is still at the appearance stage.
Yes, Mr.
Well, there is
So, my lord, the charge yet to be framed. If they have anything to make submission, well, that they may take that plea at the time of my
But
framing
suppose you
charge.
don't frame the charges for 2 more years,
Yes.
what they will do? Because for last
1 year,
1 year,
8 months.
8 months,
That is true, but let them take a chance, my lord, at the time of framing charge.
no, that is their grievance, that the court is not framing charges. And they are behind the bars for,
Because, my lord, one accused is yet to be apprehended, my lord.
suppose he does not appear.
Then alternative is there, my lord. That's
So alternative has to be taken recourse to at the earliest, because they are not at fault.
Yes.
I was provided with the valid.
Where is the e-way bill?
My lord, there, even it is with the my lord, prosecution, my lord, they have seized that. E-way bills. They have made it as a part of the charge sheet also, my lord. Lordship, page number 12, my lord. Page number 12 of my petition. Page number 12, my lord, of my petition.
Page 12.
Page 12. my lord, that contains the details of seized goods, my lord, seized properties. There, my lord, at serial number 4 and 5, column number 2, 4 and 5, lordship will find that is in their custody, my lord.
That invoice is there, but inside the drum, my lord, that 2,400 kg ganja.
Accused number 3 is the owner,
Yes, my lord.
owner of,
Owner of that rubber company, my lord.
yes, owner of the rubber company.
Rubber company.
How they will know what is there inside the drums?
Driver, my lord, he is running the vehicle, my lord, he should know what is there in his vehicle.
No,
Normal knowledge, my lord, I am carrying something, what is there?
but inside the drums, what is there, how he will know? Out of how many drums were there?
Total,
96.
96.
And the e-way bills are of liquid rubbers. So out of those 96 drums, in 48 drums, ganja was there. So it was the likelihood that consignor, driver may also be
No, but
involved.
that animals that should be there. That knowledge regarding that contraband. If it is absent, then possession cannot be attributed to the driver also. Because e-way bills were there. Those persons who generated those e-way bills, who signed those e-way bills, they were not examined. Those things are there. Therefore, it can be seen that animals with the driver is not there. He was under bona fide belief that all the drums were containing liquid rubber.
Monday. Anything, Mr. Gogoi?
My submission will be, my lord, that they I'll carried all those, my lord, illegal goods.
When is the next date fixed?
Record to up to date নহয় কিন্তু তোমালোকে জানা যদি কব নহয়
Today is also date for remand because it's still in appearance.
Oh, so after every 14 days there is.
And just regarding that possession, also just placing that Mohanlal's case.
What it says, what is the relevant para?
Relevant para is 16. Actually. That animus is required. That is what I was saying. Paragraph 16, page 12. Designation is down below your lordship will get. Custodian domain over the prohibited channel, but here I have the custody for that liquid.
And you are also pressing for long incarceration.
Lordship.
Monday or
That's why I'm handing over that compilation. Lordship.
Mistake.
And one serial number 5, Lordship. Others are Lordship has seen that other serial number 5. Colonel Singh, Lordship may only see here also that driver and helper were apprehended. They did not fled away because they did not have knowledge, Lordship. That's page 10.
Colonel Singh.
Here also, I produce all the relevant documents which I was provided by the.
Not much. Okay. Heard Mr. A. Ahmed, Learned Counsel. On Tuesday, I will pass the orders. Heard Mr. A. Ahmed, Learned Counsel for the petitioner. Also heard Mr. V. Gogoi, Learned Additional Public Prosecutor. Let this case be listed for delivery of orders on 25/6.
Make please, your lordship.
Lordship, we have filed objection here, Lordship. It may be fixed tomorrow, Lordship.
Tomorrow.
Mm.
Copy it, yeah.
Let me give a flag.
When have you filed objection?
Lordship,
It
yesterday
has not
or
come
today,
on
Lordship,
record.
Lordship. I have sent,
The objection is not on record.
Lordship, that is not in the record, Lordship. It may be fixed tomorrow, Lordship.
Instead of tomorrow, let us fix it on Monday or Tuesday.
Tuesday.
Tuesday. Heard Mr. N.J. Dutta, Learned Counsel for the petitioner. Also heard Ms. M. Deka, Learned Counsel for NCB, who submits that NCB has filed a written objection against the prayer for bail by the petitioner and prays for listing this matter on use 25. The prayer is allowed. Let this matter be listed accordingly on 25 June.
I'm obliged.
Lordship, in this. Lordship, in this matter, Lordship, co-accused bail rejected by the Honorable Justice Malsari Nandi, Lordship.
Lordship, that cannot be a bar in considering the bail application of another accused.
No,
By a
but
different court.
it should go to that court.
No, Lordship, that is only when the bail, in the bail application is rejected. The notification is like that. Notification number 18 of 2009. It says that only when the bail application is rejected in a particular case, then second bail application will go.
No, now a notification has come even with regard to the same police station, same case. If there are co-accused, it should go to the same bench.
I'm not aware of that notification. Lordship. I'm sorry.
Notification. Same court of the double line. Heard Mr. S.
N. Tamuli.
S. N. Tamuli, Learned Counsel for the petitioner. Also heard Ms.
M. Deka.
M. Deka, Learned Counsel for NCB, who submits that the another bail, the bail application filed by one of the co-accused of this case has been rejected by a coordinate bench of this court, within bracket, Honorable Mrs. Justice Malashi Nandi, bracket close, and hence prays for listing this matter before the appropriate bench. So, in view of submission, in view of submissions made by Learned Counsel for the NCB, the registry to list this matter before appropriate bench. Putul.
May it please your lordship. It's both 39 application, my lord. On basically, my lord, to commercial quantity of methamphetamine tablets, my lord. We are seeking bail only on 2 grounds, my lord. Prolonged incarceration, my lord, and release of the co-accused on bail, my lord. So in this case,
the petitioner was arrested on 14/10.
Lordship, in this case, evidence is closed, Lordship. I have received information for the department, Lordship. Only remand will be exhibited, and for that, the IO had been summoned on 4/7/2024, Lordship.
My lord, there was an order. My lord will have this order. Initially, my lord, there were 12 witnesses in the complaint, my lord. Out of them, 10 were examined. After examination of 10 witnesses, my lord, subsequently another petition was filed by the NCB for recalling one witness, my lord. Now, when my learned friend says that the evidence has been closed, the case is fixed on 4/7/2024 for examination of PW 10, my lord. Re-examination. They have PW 10, my lord. This petition was filed and my lord, on filed order dated 21/5/24, this petition was allowed. They will also have instruction on this end, my lord. So this one witness, they have again called for re-examination. So the submission that the evidence is, it's fixed on 4th of July, my lord, for examination of PW 10. If my lord allows me, also submit 2 points, my lord. My lord, in this case, the petitioner it seems so from their end, my lord, because there are 2 other witnesses. They have said that they are not going to examine those witnesses, but nothing is on record. So we do not know whether they will examine those or not, because they have not said it on record. So those are still there. Out of the 12, only 10 have been examined. 2 are there, 1 has been recalled. And this is a petition which they have filed for recalling. So we also do not know if they may file any other petition in the future. So to say that the evidence is closed is not factually correct, my lord. And my lord, if my lord permits me, my lord, I would just like to point out 3 years, 8 months, and 6 days, my lord. 1,345 days. So my lord will kindly turn to page 42 of the petition, my lord. Contraband, my lord, methamphetamine tablets, 2.146 kg. My lord, page 42, my lord. My lord, this is the bail application, bail order for the co-accused Shakil Khan, my lord. This bail application was rejected by this honorable court. However, my lord, my name is Yahya Khan, my lord. Yahya Khan. My lord. Co-accused, my lord. Joint possession, 5 accused persons, my lord. So, my lord, in this case, my lord will find that the relevant part at page 44, last paragraph. While rejecting the bail prayer, my lord, this honorable court observed, directed, however, it is provided that the learned trial court shall plan a calendar of hearing suitably so as to ensure early disposal of the case, preferably within a period of 6 months, failing which the learned trial court shall consider for the release of the accused on bail, subject to suitable conditions. But this order was passed on 2/5/2023, more than, my lord, 13 months since today, my lord. So this honorable court directed that the trial preferably should be disposed of within 6 months. If not, the trial court may consider shall consider the release of the accused on bail. Subsequently, on 18/11/2023, in light of the observations of this honorable court, the learned trial court released the co-accused Shakil Khan on bail. This is the order from page 46, my lord, and released on bail because the NCB the prosecution could not complete the trial within 6 months, my lord. So there a time frame was stipulated by this honorable court that let the trial be concluded within 6 months. So on that ground, since that could not be done, so the co-accused was released in bail in November, my lord. Now another 7 months has passed, my lord. I am still in jail, my lord. So my humble submission, 5 accused persons. Other accused persons are they are absconding, my lord. There is another Mithilesh Kumar, he is in custody as per my instruction, my lord. But 2, Iqbal Hussain Mujumdar and Babla Rahman are absconding, my lord. in trial is not, no, my lord, they are not facing trial. So, my lord, no, my only submission is that, my lord, on the, your lordship has already decided this issue of prolonged incarceration, my lord. So in this case, my lord, already I am in jail for 3 years, 8 months and 6 days. Despite a direction from this honorable court to conclude the trial in 6 months, it has gone on for more than 1 year. Now they have come and reopened the evidence. And there is also nothing on record to say that the other 2 witnesses will not be examined. So the possibility of the trial going on for even for another month or 2 months or so is there, my lord, while co-accused has already been released on it. So on this ground, I am humbly submitting that my bail may be considered.
Lordship, trial is at the end stage, Lordship. This. Lordship may fix it tomorrow by hearing my senior submission, Lordship.
My submission would remain the same. On this ground, my lord, if my lord has already crystallized all the judgments of the Honorable Supreme Court on this issue. Too long, my lord.
But Lordship, kindly pass over the matter for time being. My senior will come after some time, Lordship. He will make submission in this regard, Lordship.
Well,
No problem. 17, Lordship, allow us 7 days time only to file our objection, Lordship. Lordship, this is very new case. This is the matter of 2023, Lordship.
Lordship may record their name.
Lordship, DRI.
Let it be released next week, Lordship, if possible.
Lordship, next week. Lordship, one correction. Lordship, this is DRI matter, Lordship. DRI.
Yeah, much obliged.
Hi, Lord.
May it please your lordship. There is a 439 application, my lord. Well, the case relates, it's a charge sheeted case, my lord, relates to my lord NDPS, my lord. Here, my lord, the petitioner was arrested on my lord 24/03/2022, my lord. My lord, today, my lord, it will be more than 2 years, my lord. 22, 23, my lord, it will be 2 years, 3 months, my lord. 2 years, 3 months, my lord. And while filing the charge sheet, my lord, 7 numbers of listed, my lord, witnesses are there, my lord. Here, my lord, charge sheet was laid, my lord, on 11/6/2022. 11/6/2022, and the charges were framed, my lord, under 22C on 25/08/22. My lord, out of 7, my lord, only 2 witnesses have been examined. That is one constable and the scientific officer, my lord. And the last witness that was examined before the court, my lord, It was, my lord, 6/6/23, my lord. But today, 6/6/23, now, my lord, today is more than 1 year, my lord. No other witnesses have been examined, my lord.
My lord, only that my lord delay part is there, my lord, and but my lord, IO is yet to be examined, my lord. Yes, my lord. Out of 7, only 2 have examined. Because my lord, it is recovered from their position, my lord, and my lord, charge sheet is against them, my lord. And my lord, IO is my lord, material witness, my lord, he is yet to be examined, my lord. Yes, 1 year, my lord. Hmm.
Only one, my lord. I am the driver of the vehicle, my lord. FIR, your lordship will find at page 14, my lord, 1/4, my lord. Now, below the name, my lord, can I read, my lord? I, along with the police party, used departmental vehicle bearing number so and so, which was driven by so and so. We proceeded from PS at 5:05 AM towards the place where we could do Naka checking. Beholi pot located at Pur Boragaon near so and so. The vehicle arrives, which we were checking, and we grabbed the truck and apprehended the suspected accused driver of the above noted vehicle, Muhammad Shahadul Islam, aged about 26 years. Madam. He is before your lordship. Madam. Contraband, my lord, it's a manufactured drugs, my lord. Codeine, my lord, fancy bill, my lord. Cough syrup, my lord. Sixth, the Seizure, your lordship will find at page 18, my lord.
No, my lord, only one, my lord. Other two are witnesses. My lord, your lordship, my lord, judgment, my lord, well, it is from paragraph 11 onwards.
Delay point.
Huh?
Delay point.
From paragraph 12 onwards, my lord. All were discussed. Shahidul Islam. My lord, Gwalpara. Guwahati, my lord. Yes, my lord. My lord, if your lordship sees, my lord, previously, my lord, one of my cousin died, my lord. I was allowed to go for a limited period of bail, my lord. Then I again came. My contact is good, madam.
Surrender.
Sir, again surrender. I'm deeply obliged, madam.
For routine application lordship, CD has been called for it.
Yes, CD receipt. Lordship.
But 21 C lord. 107 days lordship, 107 days. Lordship, nothing has been found in his possession, lordship. Lordship, and he is not the owner, lordship, where the material has been found. He is the tenant, lordship. And metal found in the other part of the house, lordship, in a rented house, lordship. He is one of the tenant, lordship. FIR, lordship, page number 9, lordship. Page number 12, lordship. Yes, sir. With reference to the above, I would like to report that today, so-and-so at. Oh, gosh. So information was received by Kalyan Kumar Pathak sir, APS additional aspect for so that some peddlers were dealing in narcotics and selling the same from rented premises at Pragyotis Nagar under Jalukbari PS based on the input team under the additional SP headquarters along with Inspector Bimal Inspector so-and-so and others were informed. It came to knowledge that the peddlers had come to North Guwahati PS area for delivering contraband, but getting wind of police presence alertness, they escaped towards Guwahati. They were followed to the rented room at Pragyotis Nagar and the cartoon. The soap was contained 34 packets of heroin which weighted 414 grams. The same was seized and accused apprehended. Lordship, 107 days lordship. Yes, lordship, when he just a 26-year-old lordship. Yes, lordship. The tender is lordship, because when if more days is kept in lordship, then they lordship, so he will become every possibility of Esther lordship.
Yes, my lord, the contrabands recovered from his rented house, my lord. And now diary, it is ready for filing charge sheet, my lord. Almost, my lord, complete the investigation.
Lordship,
from his rented house, my lord.
lordship, there are court in and also lordship. My submission is that lordship, that the article, the materials has been found in the found from the other part of the rented house, lordship. He's the tenant lordship of the rented house lordship, he's not the owner lordship. But the things are found lordship in the other part of the house lordship, not from his possession lordship.
Here in his 161 matter, he has narrated everything, who has supplied those minor drugs and how they bring all those minor, that is details here.
SKS and Muhammad Yusuf.
May please, your lordship. Your lordship, I was on the concept of possession under the NDPS Act, your lordship, whether it was amount to possession or not.
No,
That
Mr.
was,
Chaudhary,
yes, sir.
you are making submissions in reply only.
Yes, I know.
So we would be very strict to the time today.
Yes,
You will be given half an hour time.
45 minutes, sir. 40 minutes. I'll finish it. I'll refer to judgments also. Point of view.
When will you finish?
45 minutes, your lordship. 45 minutes.
Maximum 45 minutes,
I'll finish it.
not a minute more than that. Start.
Your lordship.
You can finish. Try to finish earlier because
I'll. Your lordship, so first possession under NDPS Act, your lordship.
Putule record dila gusur bhai. Ah, yes.
Your lordship, I was, charge sheet was filed under commercial quantity, your lordship. Now, question of possession is very important here, your lordship. If your lordship, I'll take your lordship to the compilation of charge sheet document. From there, I have to show. If you're that's spiral binding. If your lordship, that later date 25/8/2018, which the PP started with this level. If your lordship turn to page 96. 96.
Yes.
I had shifted the whole 11 packets to my locker at my residence at police and kept it in my custody for safer custody. In mid-1990s, kg of heroin powder and missing from narcotic PS locker. So for safer custody, I took it at home. After telling the SP and the inspector that I'll keep it in my custody till further action. Now, your lordship, after this, there's another office note I have given your lordship. That is that I just, your lordship, that is page 110. Page 110, your lordship, see.
Yes.
Your lordship, page 110. This is the note I have sent to the DGP, your lordship. Kindly refer to refer office order 25. Yes, refer to that, wherein I had submitted a detailed report seizure of so and so. UBSL on that. If your lordship will see third para. Therefore, in this connection, kindly approve and allow me to have it deposited in narcotic malkhana at the earliest. My plan was to trap the year owner. Your lordship, here question is, it is within the knowledge of the I have informed the DGP. It is in my custody, your lordship. It's kept here, your lordship. So as a result of this, position, because and if your lordship will see the if your lordship see this also, there that notice of 6/11, your lordship, that notice 6/9/2000, where they have stated that it was kept in my custody, your lordship. That is at page, your lordship will see. Page that suspension order that you have stated, your lordship. There it has been stated, I was charged on keeping in custody the drugs, not for possession. Keeping in custody. Keeping in custody and possession are two different concepts, your lordship. So possession doesn't come here, your lordship. Then if your lordship, if possession is there, if they know the second seizure is bad, 1/9/2018, the second seizure by which the drugs are seized from me, that is bad. They cannot have a second seizure, your lordship, in that regard, your lordship. That seizure memo, if your lordship will see, that is at here. 1/9/2019, 2018, your lordship. That seizure. That is bad, your lordship. That cannot be a second seizure, because then the seizure will, when seizure will come, your lordship, when they have knowledge that someone is in possession of the drugs and they went and seized the thing. Here, it is within the knowledge of police authority that is just kept in my custody and I want to give it to them. Here, this letter is very clear. I want to give it them. So there cannot be seizure of this. And based on which an FIR cannot be registered, Your Lordship. So this is a humble submission, Your Lordship. Now what he has said, he has asked permission to deposit the drug in the Malkhana here. He asked permission. So according to 19/2000, he sent these people to this thing. So it should be a receipt memo instead of seizure memo. That they have received the thing. And there is no shortage also, Your Lordship. Everything is all intact, Your Lordship. Then I take Your Lordship to the CFSL report, Your Lordship. So this is what I have considered because how that because and the CFSL report, Your Lordship will see. If Your Lordship turn to page 77 of that this thing, Your Lordship, that queries paid by the IO, Your Lordship, page 77, Your Lordship will see.
Yes.
Your Lordship say question here, if you look at that, they please examine and give the valid opinion under this thing. Whether the suspected items marked in exhibit 1 to 3 are prohibited narcotic drugs. 2, if so, what is the market name of the product? 3, what is the purity of the item marked in exhibit 1 or 2, 3? Please furnish the estimated value of marked area marked to 1 to 3, Your Lordship. So these are the queries made. Now let us see the CFSL report, Your Lordship. CFSL report is at page 80, Your Lordship. Here, if the following results were obtained, the opium alkaloid named morphine, codeine, theanine, papaverine, and narcolepsine were detected in the context of each exhibit so and so, so and so. Here, the contents, nothing is there, Your Lordship. Now, if Your Lordship will see the NDPS Act, Your Lordship, out of these 5 items, only 3 items are there in the NDPS Act, Your Lordship. But take Your Lordship to the thing, Your Lordship, NDPS Act. That schedule, if Your Lordship will see.
What 3 are there? Morphine, codeine, and
Yes. Your Lordship, if Your Lordship, I marked it here, if Your Lordship want to see it also. This NDPS Act, Your Lordship, serial number.
no, you may tell me. I will.
Yes, Your Lordship. It is here, Your Lordship, is there.
Which 3 are?
3 morphine is there. Codeine is there. Yeah, just 2, 3 are there. Just morphine is, I just have used serial number. Serial number 28 is codeine. Then serial number 77 is morphine. Then serial number 1T is thiophanate. Now, if Your Lordship see the act, Your Lordship, they are given commercial quantity, Your Lordship. Here, nothing is, no amount is been there. So, commercial quantity cannot be determined in terms of serial. If Your Lordship will see the column 6, 5 and 6 of that schedule, Your Lordship, they give the column because so far, codeine is concerned, here the amount is 1 kg. This is a commercial quantity. So far, morphine is concerned, it is 250 grams, 77. Then so far, Your Lordship, thiophanate is 100 grams. So if Your Lordship see the CFSL report, nothing is stated about the quantity, Your Lordship. So as a result,
how CFSL would speak about quantity?
what they have asked, they asked for this thing.
They may ask, but
Yes.
CFL, you are sending only samples.
Samples, but the question is sample also determine their what they have not, if from the sample also they should determine this is the amount we have got it. They have not stated anything, Your Lordship.
Percentage.
Yes, that's it. How can it be put in commercial? Maybe the normal quantity also. You cannot put in commercial without the materials, Your Lordship. They may have
No,
materials.
it does not depend upon the CFSL report.
No,
Whether it is of commercial quantity or it will be dependent on the inventory and the seizure memo.
Yes, sir. Seizure memo doesn't say that. Seizure memo is only because the question is the detection is out of this, what have they detected? If Your Lordship will see, this drugs packet were kept with them from 19/2000
18 till 5/12 to 5/11/2018 for so many, almost two months, 5 days. They have not deposited the code also. So these have been kept in the custody, Your Lordship. And after that, when they ask for these things, and nothing has been stated, Your Lordship, because for commercial, there are some materials to they charge me on to file the charge sheet in commercial quantity, Your Lordship. There's nothing in the record just to show it's a commercial quantity, Your Lordship. That is my respected submission, Your Lordship. Because commercial quantity has to be shown, Your Lordship.
Mr. Chaudhary, I'm again reminding you,
Yes, sir.
I'll not give you a single minute.
No, I'll finish it, Your Lordship.
You have to finish it.
I'll just finish up it. Then, Your Lordship, if Your Lordship will see, so this because so far NDPS Act is coming with commercial quantity. Now another aspect of the matter is here. Suppose if Your Lordship is saying possession is there with me. If possession is there, there cannot be entrustment under section 409, Your Lordship. Possession and they cannot go together. If you charge me under this thing, possession cannot be there. The entrustment cannot be there. Under 409 and for this, Your Lordship. Entrustment has to be specific, Your Lordship. I have entrusted the matter and this thing. So, Your Lordship, these two charges, they have filed a charge sheet under section 21C of the NDPS Act as well as 409.
409 does not lie, according to you.
Yes, Your Lordship. Because if possession is with me, then they have not entrusted me the thing. Entrustment will come from their side. If there is an entrustment, then only I'll get the thing. But there's no entrustment. And the question of cheating also doesn't come. Because they have to give some material which I have cheated them. So this charge sheet under 409 to 420 also goes away, Your Lordship. These three things, Your Lordship. Just these things goes away, Your Lordship. Then, if I take Your Lordship to the judgments, Your Lordship, you have referred on this on what basis this 409 will lie, Your Lordship? That is 2012 8 SCC 547.
Yes.
My Lord has got it.
Yes.
Now, para 14, Your Lordship, see. Para 13, they report the second. In order to prove the offense of criminal breach of trust which attract the provision of section 409, the prosecution must prove that one who is in a manner entrusted with the property. My Lord has got it.
Yes.
In the case as a dealer of fair price shop, dishonestly misappropriates the property, commits criminal breach of trust in respect of that property. In other words, in order to sustain conviction section, two ingredients has to be proved, namely, the accused is a public servant or a banker. There is no problem with his and anything. The accused has committed criminal breach of trust. What amount to criminal breach of trust is provided in section 405. The basic requirement to bring home the acquisition of section 405 are the requirements to prove conjointly entrustment and whether the accused was actuated by dishonest intention or to misappropriate it or convert it to his own use to detriment person. So here, Your Lordship, there is no entrustment and there is no complaint the amount is less. After seizure also, they have not said the amount has gone down. They received the same amount. In the charge sheet, everything there is that they have not stated anything that they have not received the amount which was with me. So their interest that this goes away. There is no dishonest misappropriation is there. Then if Your Lordship goes to para 17, it is clear that the prosecution, even that the appellant was not in a position to show the correct details, particularly the handing over of the rights to the beneficiary by securing coupons, vouchers. This is fair price shop thing, though it was stated the appellant all those coupons, vouchers were in this father. It was demonstrated that his father failed to turn up even after 12 months on so and so. Therefore, there is no dispute that the appellant was entrusted with the 13.8 quintals of rice, kerosene, soy, fair price shop, medicine, so as he was only entrusted 6.8 quintals of rice, so and so. So, Your Lordship, here they have clearly stated this thing, Your Lordship. Now, para 18, Your Lordship. Para 18, the material placed by the prosecution show that the appellant accused has dishonest intention
not to distribute rights properly to beneficiaries of the area, criminal breach of trust could be made out, as observed by the appellant accused so and so, so and so. Here, a dishonest intent is also ruled out, Your Lordship. So 409 is gone, Your Lordship. Now I come to the next judgment where 420 is there, Your Lordship. That is, if Your Lordship take 2022 SCC online, SC 1061, Your Lordship.
$2,000.
SCC online.
Yes. Para?
My lord has got it.
Yes.
If Your Lordship turn to para 13. The ingredients of offense of cheating are spelled out section 14 of the so and so. Your Lordship is said. 14 is the ingredients of the offense under section 415 emerges from a textual reading of firstly, to constitute cheating, a person must deceive another. There is no deceive here. Secondly, by doing so, the former must induce a person so deceive. There is no inducement also. Delivery any property to the any person or to consent that the person shall retain any property. Or 3, intentionally induce the person so deceive to be or do omit to do anything which he would not do or omit if he is not said to deceive, and such an act omission must be the cause likely to cause damage to harm so and so minor. Here the allegation against me is that I have asked them to give me the their allegation is I have asked me give the this thing and I have kept it in my custody. So there is no question of cheating is not there. It is not there is no inducement, nothing is there. Then the next section 420 deals with cheating and honestly delivering of a property. It is not there, Your Lordship. Then section 14 is quoted here. So here Your Lordship will see para 16. Your Lordship will see that the bold para 15 bold. I did not trouble Your Lordship. Mere breach of contract cannot give rise to a criminal prosecution for cheating unless fraudulent or dishonest is shown right at the beginning of the transaction. Here has to be, this has to be shown. Then nothing has been shown here, Your Lordship. That is the time when the offense is said to have committed. Therefore, it is the intention which is squeezed of the offense to hold the person guilty of cheating. It is necessary to show that he had fraudulent or dishonest at the time of making the promise. From his mere failure to keep the promise subsequently, such culpable intention right to beginning, that is so and so. So here there is no promise made at all, Your Lordship. So the question of cheating also goes away. Then if Your Lordship will see para 17, that I just read the bolded line. If the dispute between the parties were essential civil dispute resulting in this, I have not concerned, appellant by non-refunding of amount as would not consider similar local legal position to respect of offense of criminal breach of having regard to definition of content in section so and so. Your Lordship will see. Then applying the above principle, the ingredients of section para 18 as 415 and 4 are not made out in the present case. The grievance of the first person arises from the termination of service in the hospital, the allegation in this so and so. So here, this is the facts of the thing. Now, if Your Lordship go to the criminal breach of trust, para 21, Your Lordship. The offense of criminal breach of trust contain 2 ingredients. 1, entrusting the any person property so and so defined person interest dishonest so and so. This has been dealt there also, Your Lordship. Then entrustment is there. So if Your Lordship will see these 2 judgments, it clearly shows that 409 and 420 is not at all attracted now. Now, now I come to another judgment, Your Lordship, that is under the Prevention of Corruption Act. If Your Lordship, Prevention of Corruption Act also.
Where?
Because Prevention of Corruption Act, if Your Lordship will see, I have been charged under Your Lordship. 7A and 7C, Your Lordship. Section 7A, 7C, Your Lordship, see. 7A.
Yes.
7A is often, Your Lordship, may I point out one thing? So far PC Act is concerned, so far Nagaland is concerned, the jurisdiction to try an offense of PC based on TDP, Tribunal for Disciplinary Proceeding, that goes to there. Special judge doesn't have to, they have TDP court also headed by a special judge, Your Lordship, Nagaland. So here, even I put that is what yes, that the court doesn't have the jurisdiction, special court doesn't have the jurisdiction to try the offense of prevention of corruption. That has been tried by a separate court.
What that court is known as?
Tribunal for Disciplinary Proceeding, TDP.
Okay.
TDP. Capital T. That is where the government servant PC Act. They have a tribunal for that, separate tribunal. Now, if your lordship will see section 7A, because if your lordship will see, so for the corruption part, there is nothing on corruption part. If you see the investigation report, there's nothing, no element of corruption is there. Only thing, they relied on an SMS of that we are making the magistrate reach by this thing, via this thing. That doesn't make me a corrupted person. Unless there's something is materialized in fine, I have been benefited by this transaction. So if your lordship will say that there's nothing, no material on record, if your lordship say on corruption, your lordship. Even the disciplinary proceeding which are instituted against me, which could not be concluded by them till today. There also corruption charge is not there. Only drugs, keeping of drugs, not registering of, I'm not allowing them to register an FIR, all those things are there, but nothing on PC Act. Even if you like that memorandum of charges of discipline, I have annexed in my document also, nothing is on PC Act. That is memorandum of charges 18/12/2018. If your lordship will see, nothing is there on corruption. I just give it to you, that is there on the record.
Okay, okay.
Then I take your lordship 7A, your lordship. Obtains a officer public. Any public servant who obtains or accepts or attempts to obtain from any person an undue advantage with the intention to perform or cause performance of public duty improperly or dishonestly, or to forbear a cause for bear to perform such duty either by himself or by another. So here, your lordship, what has happened? I have kept that with me. But as soon as they asked, I gave it back. So where is the question of corruption here? I didn't get any advantage for that. They have not shown that by keeping the I have some advantage here. And whatever material they have given to me, I returned to back them. Nothing was kept with me. Then C is perform the inducer any public to perform improperly or dishonest any public duty or to forbear perform such in any application or consequent directive any person shall be punished or imprisoned for a term which shall not be exceeded 3 years and so. So here, your lordship, again the same thing, nothing is there. Now, your lordship, what they are trying to implicate me by section 164 statement of the two co-accused. There is no material. What they have alleged orally that has been done. Nothing has been there, your lordship. So PC Act, if the judgment, I gave a judgment also, your lordship, 1992. 4 SCC 45. This is under old act, your lordship, but these things are there. Old act, that is 47 act, your lordship, but for this thing, if your lordship see para 6, para 6. Yes. An analysis of section 5E of the Act 90, which corresponded to section 13E, 1E of the new Act of 90, shows that it is not the mere acquisition of a property that constitutes an offence under the provision of the Act, but it's the failure to satisfactorily account for such possession that makes the possession objection as an offensive. To substantiate a charge under section 5(1)(e) of the Act, the prosecution must do the following ingredient, namely, the prosecution must establish the accused a public servant, the nature and extent of pecuniary resources or property which are found in his possession. It must be proved as to what were his known source of income that is known from the prosecution, and fourth, it must prove quite objectively that such riches or property found in possession of the accused were disproportionate to his known source of income. Once The above ingredients are satisfactorily estimated, the offense of criminal misconduct under section 5 is complete unless the accused is able to account for such resources or property. In other words, only after the prosecution has proved the required ingredients of burden or satisfactory accounting for the prosecution of such resources or property shifted to accused. Then, your lordship, I take your lordship to then para 14, your lordship. Para 24, your lordship. On the face of totality of the above circumstances, the cumulative effect, and therefore according to the prosecution, cannot be said to have successfully fixed the criminality of under section 5 of the Act on the appellant who had completed an unreleased service record as well. So having regard to so that here are district the found judgment trial court appellant so imposed. So your lordship is clear that this in this case also nothing has been shown, nothing, no pecuniary advantage, something has been shown. So PC Act also goes, your lordship. NDPS PC Act also goes, your lordship, because and then your lordship will see. Here your lordship will see the charge sheet. One base of charge sheet has been filed, there should be material to substantiate it. According to the materials are not sufficient at all to file a charge sheet under those provisions, your lordship. Neither under section 21C, nor under section 409, nor 420, nor under your lordship 5, the PC Act also. All this charge, nothing, no materials have been there. And the whole investigation was against me was directed to save two of the other police officers who were all fully responsible for the whole episode. The OC of the police station and the in charge of Malkhana. And I have already shown that Malkhana, this thing they have, it is all interpreted at a later stage. That is so that Malkhana all have been manipulated, your lordship. Then your lordship will see on these issues, your lordship will see that
you have already made these submissions.
yes, that's it.
You are repeating at your. No, but you are repeating at your own cost.
I am summarizing it here.
I will not give you extra time for that.
Yes, so then your lordship will see that on the investigation by CBI, the other one, your lordship, the CBI investigation, your lordship, judgments have been referred. I just referred to the judgments also. One was that by other side, your lordship, that is 2013, because conclusion paragraph got 2013-12 SCC 480, your lordship say.
By the public prosecutor.
Yeah, she has relied on. She has relied on paras, but other paras are very important. If your lordship started para 7. Para 7. Agreed by the DSP so and so, previous so and so. The High Court has declined to hand over the investigation CBI. Therefore, it was not proper for the High Court to pass a fresh order on petition that is disposed directly against the inquiry made by CBI. The view was so and so. The court also took a note of the fact that it was not the application of the appellant to transfer the case to CBI. Thus, the transferring the investigation to the court kept it open that the appellant could prefer a fresh criminal under section 482 for transferring the inquiry from the state police authority, depending on the subsequent events. Then you have para 8. The appellant has some so and so. Being satisfied this para 8, 9, if you will see. Then I go to para 8, 9 as important. 8. Then your lordship goes to 9, para 9, then para 13. Para 13, because these are all extract of the judgment, your lordship. Para 13 says the issue in para 13, your lordship, then para 14, your lordship. Then para 15, I have referred to the judge of West Bengal that I need to travel your lordship that thing. Para 16 is important, your lordship. Then if your lordship goes to para 17, 18, 19, 20, 21, 22. 22 was the one referred by. So all these paragraphs are to show from this, it is clear that it is a case where the matter has to transfer to CBI because here 2-3 effects are there. Here your lordship will see. The main complaint has not been registered in FIR and nothing has been done. 2 of the police officers are involved and police officials are also involved with it. So CBI investigation is also independent, impartial is there. Then they have referred to Arnab Goswami judgment also. That is also a different point here. Arnab Goswami judgment, that is 2020 14 SCC. 14 SCC, page 12.
No, what is your counter to?
Yes.
She has cited these judgments.
Yes, sir. Cited this judgment. I said this judgment, this judgment. There is no doubt of the proposition of the law. There is no doubt. I'm not saying. Question is whether this case be transferred. That is another aspect. Proposition. I'm not disputing the proposition of law. That court has to rarely exercise. Those things are there. Even this honorable court, I have given a judgment also. This honorable court where they transferred the investigation CBI from the state police, your lordship. That judgment was delivered with just Ujjwal Bhuya at that point of time, your lordship. That I given a judgment, your lordship. Where it has been investigation transferred to CBI also. Because when you find that justice is not being done proper, cannot be done, the court has a wide power. Herein, so for transferring to CBI, the court has a very wide power, and it is self-imposed repetition. What they have said, it is self-imposed repetition. It's the court's discretion whether to go for CBI inquiry or not. Now the case is, your lordship, how the drugs have come, that has not been investigated. 6.9 kg of alleged brown sugar has been detected, but there is the 2 persons who are drug peddler have been made prosecution witness in my division proceeding, your lordship. So that these are very strong grounds. How that drug peddler have become prosecution witness? Then your lordship will see police officials are involved and they have been exonerated by section 164 statement. That is also unknown. So if that's what the whole investigation is totally malified, your lordship. Just the investigation was there to save these 2 police officers, PW 2 and 3, your lordship. By the state government.
Yes, you have already made these.
Yeah, no, that's because your lordship asked me how I'm not because why CBI investigation. These are the reasons why CBI investigation is required, your lordship.
Okay.
These are the reasons why compel it should weigh in the mind of a lordship to transfer to CBI, your lordship. Because CBI is an impartial investigation. If they're innocent, why they are scared of CBI investigation? They will be acquitted there also. I am also, if the CBI investigator wants to have with me, I have no objection to that. If the CBI investigator goes and find me guilty, they can go and proceed against me. I'm not quarreling on that. But why they are so shy of CBI investigation? Because all the cat will come out of the bag. Whole thing will come out, the whole racket will come out. Drug peddling record will come out because whole it coming from Myanmar to your Manipur, Nagaland to Assam, all those things. So the whole racket will be exposed. The big racket going on, your lordship. So your lordship, seeing the national scenario of the people, your lordship, this is a fit case where CBI inquiry has to be given, your lordship. It's a fit case where, because Arnab Goswami judgment is a different aspect, your lordship. Because para 52, if your lordship will see, Arnab Goswami judgment, my learned friend refer to all the judgment. I am not querying over the judgment ratio, your lordship.
Okay.
That para 52 is very clear, para 52 of that Arnab Goswami judgment. In ascertaining the condition of transfer of investigation CBI, we have factored in decision-making calculus. My lord has got it.
Yes.
The averment on the record and submission are on behalf of that. We are unable to find any reason that warrants transfer into the CBI. In holding that, we have applied the test spelled out the constitution line of the precedent of the court. They have not been fulfilled. An individual under investigation has a legitimate expectation of a fair process, which accords with law. The displeasure of an accused person about the manner in which the investigation proceeds or an unstructured as in the present case, in conflict of interest against the police conducting investigation must not derail the investigation course of the warrant invocation of the extraordinary power of the court transfer the investigation. So it is very clear, your lord. Now your lordship will see why once first charge is taken away, second charge is the second charge. So all these things are there. So all these circumstances of the whole case will be a capsule for your lordship to transfer to CBI. The whole, you have to know the whole gamut of the whole thing. If your lordship were to go through, Not only one instance, not seeing the receipt, they have to, the facts has to gone in each and every facts. Your lordship, 3 sanction order, this, all charge sheet has been taken, replaced by another charge sheet. All these things have to gone into your lordship. Because that cannot be, that's on record. They cannot deny these things. There are 2 charge sheet number I have shown, there are 2 charge sheet number. Charge sheet number 3 of 12/11/2021 and charge sheet number 03 of 14. How can there are 2 charge sheet numbers? So all these 6 factors are there, your lordship. I think it's a fit case where your lordship has to question this petition and transfer the investigation that, because your lordship, the 3-8 complaint and this thing, that has not been touched by investigating officer. What will happen to that? It's a cognizable offense. It has not been tried. 3/8/2018, where the drugs was in Kozama checkpoint was, that has not been gone into your lordship. Keeping in custody has been gone into and it has been prosecuted. But the main thrust of the matter, they are scot free. And state is not, till now they have not registered an FIR against those people. Why? They have not given any reason for that. So all these things have to gone into your lordship.
Wind up.
So your lordship, what I'm saying, the whole crux of the matter is that he has retired also, your lordship. He has retired on 31/12/2023, your lordship. Because of this, he's not giving pension, nothing. Because he has been humiliated like anything, your lordship. Not being given any benefit, nothing. Discipline, they couldn't complete discipline. They were, it was went to Supreme Court. Supreme Court has given extension of time, they couldn't complete it also. There's no material against him. What DP will they do? 2018 to 2024 June, they have expired that they couldn't do anything. For 19, 20, 21, 20, 23, 24. Almost 6 years. No DP. See, DP has to finish in 180 days. 6 years they couldn't do anything. So this is the plight of the whole thing, your lordship. They have no materials, even all their materials are contradicting themselves. The materials which are submitted, if your lordship will see, my written service have dealt with those, and if your lordship will see those all the documents, it's absolutely clear that nothing is against me, your lordship.
Okay. Okay, now wind up.
Yes, sir. I'm deeply obliged for a patient.
Okay, you don't have any. You have nothing to respond because. Do you have anything to say?
Lordship, I have already submitted in the earlier occasion. The only thing is that just one line, your lordship, from the materials placed before your lordship, from the record, there is a prima facie case that the petitioner had committed a criminal offense. So the interference of this honorable court is not warranted. That's my plea, your lordship. That's all.
Heard Mr. P. Chaudhary, learned senior counsel, assisted by Mr. Who will assist?
Yeah, he can assist. I have one simple prayer, your lordship, Mr. Lordship.
Whose name is there with you in the affair, in the first list? Oh, wonderful. Assisted by Mr. D. Talukdar, learned counsel for the petitioner. Also heard Ms. V. Sokre, learned public prosecutor representing the state of Nagaland. The hearing is concluded, judgment reserved.
I want to make one simple prayer. Because what is happening, your lordship? Because he has to be there before the special every time, your lordship. Your lordship, stay for the timing till the judgment. Because he has to go to the.
I have reserved the It
Because-
will be finally disposed of.
Because I'm checking because he's got a lot of problems are because he has to go with security and everything. Because he doesn't get security also now.
That you have to face till the judgment comes.
Yeah,
It may not come.
they won't do it, Your Honor. So what I'm saying, Your Lordship, till that time, because
There is no such petition for stay. You have,
stay was there, stay of proceeding is there, never been. It's there. Notice has been issued, but since it was hearing, we didn't press for it.
we are finally disposing of the matter. Wait till the judgment.
I'm highly grateful to Your Lordship for giving a patient hearing. I do not know how much I could assist Your Lordship.
No, both of you have assisted a lot.
No, Your Lordship. With my limited knowledge, I don't know how much.
Yes, Mr. Majumdar,
Lordship,
you will get 15 minutes time.
Lordship, yes. No problem because already Lordship already had the better Lordship earlier because only the LCR was called for by this honorable court Lordship about scan copies of the and I am relying on some judgment Lordships because admittedly she was major at the time of marriage.
The present petitioner is also facing the trial in the same case. And he is not differently situated.
Lordship, my.
That is his submission.
Yes,
Let-
Lordship.
What I have heard.
Lordship,
And
this
and the delay is already of 3 years, 8 months, 6 days.
Yes.
So they are pressing for bail on the ground of prolonged incarceration.
What's my first submission? All the evidence has been completed. Next date is fixed on 4/7. This is my first submission.
474?
Evidence has been closed. That I have to, because I have been informed by the IO that evidence has been closed and next date is fixed.
But
on
you have called for, you have filed an application for re-examination of PW 9,
10.
PW 10.
No, Lordship, that time, no, but I have been informed by IO just now that evidence has been closed and next date is fixed on 4/7/2020.
For what?
That's Lordship, I am not.
No, that is important.
That is not informed to me, Lordship.
It is for the examination of PW 10, re-examination.
Then, that's I'm not aware, Lordship. Lordship, regarding parity, in my humble submission, parity cannot be a ground. Lordship, may I please to come see this full bench judgment of Supreme Court quoted in yes. Lordship, may come to paragraph 11, Lordship. This is the
Of
Supreme Court full bench judgment. Lordship.
which
In this report, what happened? The Karnataka High Court granted bail to 3 persons. Then NCB approached Supreme Court. Then Lordship Honorable Supreme Court of the perusal of the materials confirmed the order with respect to 2 accused. But Lordship, paragraph 11 may kindly listen.
yes, what it says,
Lordship, I'm reading Lordship.
you read the relevant part which
Yes,
you.
paragraph 11. However, the evidence brought before us against Muhammad Afzal, accused 2, respondent in SLP number so and so, subject matter of the second case, NCB case number so and so, who was granted bail by order dated 8 January 2020, will have to be treated on entirely different footing. There are specific allegation leveled against the said respondent regarding recovery of substantial commercial quantity of drugs from the rented accommodation occupied by him, pursuant to which he was arrested on 16th June 2019. This aspect has been completely overlooked while passing the order.
So they are not at parity.
Yeah, this is my Lordship, another Lordship.
No,
Further-
in this case, what I understand, that if accused person are not similarly placed, they will not get benefit
No,
of parity.
Here there are facts of the case was that 3 accused persons were granted bail by the Karnataka High Court. NCB filed application for cancellation of bail. Then while considering with respect to 2 accused who had been arrested on the basis of 67 statement, their bail was confirmed. But with respect to accused number 2, Lordship Supreme Court has observed that quantity was recovered from rented house.
Yes, because on facts, he was differently situated.
Yes. Now,
Therefore,
I'm coming to that. Lordship, let me complete because some observation is there. This aspect has been completely overlooked while passing the order dated 8 January 2020, wherein the only reason for appears to have been waited by the High Court for releasing him on the bail. His case stands on the same footing of accused AN3 and accused A4 and has been enlarged on bail by the order dated 11th October 2019, 16 September 2019 and 9 September 2019 in connection with the second case registered by the department. We are of the firm view that accused number A2 cannot seek parity with the aforesaid co-accused. No such benefit could have been extended to him in view of section 37 of the act when he was found in conscious possession of the commercial quantity of psychotic substance as contemplated under NDPS Act. That being the position, the petitioner NCB succeeds in self-in so and so, and accordingly bail was cancelled. Now, Lordship, come to page 37. Paragraph 42.
37.
Page 37, paragraph 42.
Yes.
Evidence against accused Muhammad Yahya Khan. In the instant case, 1.32 kgs of methamphetamine tablet form was recovered from direct physical possession of the accused Yahya Khan, which is more than 20 times of the commercial quantity specified methamphetamine in notification number so and so. As Mr. Yahya Khan has knowledge of the fact that other two accused, namely Sahil Khan and Mithilesh Kumar, also had methamphetamine tablets in their possession, and he, along with other co-accused, has intended to deliver this whole consignment of methamphetamine tablets. Receiver of the accused Yahya Khan was in conscious possession of the so and so. Now, Lordship may come to page 42.
No, what, how much
1.013 kgs of methamphetamine tablet.
from him?
Yes, sir.
And from this person who has been released on bail?
Yes, Lordship. Lordship, page 30, previous page. Paragraph 41.
Shakil Khan.
Yes.
He was also found in possession of
Yes, Lordship. Quantity was different. Not a small quantity.
275 grams.
Yes, 75 grams. 275 grams. Now, Lordship may come to page 42, where why this honorable court passed conditional order. Bail was rejected, but a proviso was made. Page, Lordship may come to page 44.
Yes.
Last paragraph. However, it is provided that the London Trial Court shall plan a calendar of hearing suitably so as to ensure early disposal of the case, preferably within 6 months, following which the London Trial Court shall consider release of the accused on bail subject to suitable conditions. Nothing was considered, whether it was a commercial quantity or below commercial quantity. Only on the ground a time frame was fixed. And Lordship, recently in the case of Allahabad High Court Bar Association case, Supreme Court has clearly stated that the Constitutional Court cannot fix a time limit for disposal of a case. Only in case of special circumstances, court can pass order. And on this ground, he filed bail application before the trial court. He was granted bail.
Okay.
And Lordship, in my humble submission, that paragraph 11 of the judgment coupled with the facts of the case, in my humble submission, and further, the trial has already, evidence has already been closed. And Lordship, regarding on 4/7/2024, why the case is not fixed at this stage, Lordship, I am not in position to appraise your Lordship. So under the circumstances, Lordship.
No, that information is important.
That is for the re-examination of PW10.
That can be seen from the this
E-courts also.
E-court.
Yes, sir.
Well, I may respond to what my learned senior friend has submitted. Firstly, regarding the order of this honorable court, which my learned senior friend has submitted, that there was no mention regarding commercial quantity, anything of that sort. Page 44, the paragraph which has been relied, immediately the paragraph before that, my lord. The very reason why this bail was rejected was because of the offense was of commercial quantity and the rigors of 37 were there. Now, my lord, we are not even claiming parity on the ground that we are similarly situated vis-a-vis the allegation. Irrespective of that, my lord will kindly come to the Seizure list, my lord, at page 18.
Yes.
They have made a conjoined Seizure list, my lord. With one same Seizure list, my lord, they have showed recovery of the contraband, my lord. Number 1, methamphetamine from Mithilesh Kumar. Number 2, methamphetamine
What is
for
the quantity of methamphetamine?
50 grams. 50 grams.
50 grams.
50 grams. So 1, 2, and 3, my lord, there are 3 entries from 3 different persons, but the seizure has been made by the same Seizure list, my lord. So even vis-a-vis the allegations, my lord, what the NCB is showing that they were in the same place, my lord. Same place the seizure was done. Obviously, they are trying to project that it was done separately. But seizure of commercial quantity from each of the 3 accused persons was done. Subsequently, my lord, this person has been in jail for now 3 years, and that itself, my lord, 3 years, 8 months, and 6 years, that itself constitutes prolonged incarceration, my lord. That itself, in my humble submission, makes the petitioner entitled for bail.
Okay.
Apart from that, my lord, what even the judgment of the Allahabad High Court Bar Association, what does the judgment say? The judgment came in response to the Asian resurfacing judgment. What the Honorable Supreme Court said that ordinarily, constitutional courts should not fix a time-bound schedule. The language used is therefore constitutional courts should not normally fix a time-bound schedule. These are not normal circumstances, my lord. A person being in jail for 3 years.
Here we are not fixing a time-bound
Yes, no,
schedule.
no. What is
Here the question is how I understand, how I look into the matter. You make me understand if you think otherwise. Here the court, while considering an application for bail, is concerned that whether his incarceration is long. The trial may go on. If he is granted, the question is whether he is to be granted bail or not. It is not to stall the trial. Trial can even go on after he is released on bail. So the question of putting the time-bound schedule for the trial is not the major area which this court would look into. This court would look into the fact whether incarceration is long enough.
Yes, that up to Lordship is to decide
that
what will be the time limit.
Yes.
Where we can say that this is
Vis-a-vis every fact situation
may be different.
may be different.
Yes, Lordship.
Whether in this instant case his incarceration is long enough.
Yes, that is to be decided by Lordship. In my humble submission, in case of NDPS, Lordship, this is not an incarceration because this earlier before September until case, there was no time limit fixed for in NDPS cases, and Code 36 capital A was not applicable in case of NDPSA. But since then,
No. That is not.
Yes, Lordship, this is the
No.
point
How I understand.
Lordship.
You make me.
No.
It is not that 436 was earlier not applicable. Satyendra Singh case make it clear that 436 is also applicable.
Yes, Lordship.
It was applicable earlier also, but it was not made applicable.
Lordship, yes, in case of NDPS, it was not made applicable.
Not made
Yes.
applicable. It only clarified that 436A is applicable
In case of
even in
NDPS.
NDPS case.
So Lordship, if we go by the section 436A, then half of the punishment we have to calculate, maximum of
But
the
there are lots of judgment.
Lordship, that's why this is my submission that cannot be taken as a precedent, Lordship, because our High Court has clarified in different judgments. If Lordship allow, I'll place that judgment also. Ordinate benches differ on this point that cannot be precedent for decide a case, Lordship. And Lordship, I have gone through the many judgment.
No, we are not deciding on the precedent.
No, Lordship. To make Lordship clear, I may have to realize some judgments because they are my learned friend is not relying on Ravi Prakash, one judgment Ravi Prakash. And 4 orders of, which got from the Bengal High Court, where in 1 year, 1.5 year, 2 years and 3 years bail was granted. So that cannot be treated as a precedent, Lordship. Then Lordship has to decide what will be the time limit for completion of trial. And what will be the long incarceration. Even if it
Now,
is
what
1
would be the long incarceration would depend on facts of each case.
Yes, because Lordship has to see the trial.
For that, there may not be any precedent. But court can certainly look into.
Yes, Lordship. This is my point to be placed before your Lordship. The Lordship has to decide what will be the, because the Lordship has to see the purpose of the act and what is the offense committed by the, because in Gorwat Singh, Supreme Court says that in case of serious offense, delay in trial cannot be a ground for seeking bail. Although it was relating to UP Act. But this was also heinous crime and this is also heinous crime. Probably there may be not any difference with regard to NDPS case. These are not heinous crime.
No, but in lot of NDPS cases, Apex Court has granted.
Yes, Lordship, this is my point. Whether it can be taken as a precedent, Lordship. I have placed some.
This is not taken as precedent in.
Yes, Lordship. Then Lordship has to decide what will be that delay will be considered as a long prosecution, incarceration, Lordship. Then Lordship has to hear on that point also.
No. I have understood your submission. I have to decide on the facts of this case, whether under facts of this case, the incarceration of 3 years so much
And if
is
I have a
long enough
submission,
on.
since trial has already been come to, all the evidence has been closed. This is my humble submission. Secondly, that Palladevi Raman case, Lordship. Because when the conscious position, the narcotic has been seized from the conscious position, then he is not entitled to bail. And
What was in that case? What
Which
was
was
the period of detention?
But here difference is that trial
Case, Harimutta's case.
is at the end, Lordship, in this case.
Was it on long incarceration?
No, Lordship.
No.
It was on 67.
It was on
67.
some other ground they
67.
were seeking parity.
In 67, 3
Here, his submission is very clear on 2 points. One, you have countered regarding parity. Other submission is solely on ground of long incarceration. And your submission is that it is not long enough.
It is not long enough.
Vis-a-vis the stage of trial.
The stage of trial is already, all the evidence has been, witness has been examined.
Okay.
This is my submission, and Lordship further. Lordship, with regard to long incarnation, I didn't find any judgment subject to what my learned friend says that in none of the judgment, it has been, what will be the period that we consider as a long incarnation.
Yes.
That is not and Lordship, we take the analogy of section 436A, then Lordship, half of the punishment. And here the maximum punishment is 20 years. Even if we consider 10 years, then also 5 years to be considered. Then it will be automatically they will be entitled to bail. And we can safely say that yes, this is a long incarceration.
No, I am not convinced with your submission that.
No, that is up to your Lordship.
Whether your Lordship for 10 years for an offense for an offense where the punishment is 20 years, for 10 years you remain.
Yeah, this is the law.
No, that is not my query. Listen to my query. If you take that for an offense for which the punishment is 20 years, for 10 years you do not do anything, merely detain the accused.
Yes, that has to see, Lordship, what is the stage of trial, how many witnesses have been examined.
Because today we found cases where even charges are not framed for 2 years.
Then Lordship has to see what was the reason why charges.
Therefore, what I understand, we have to see the facts of the case.
Yes, facts of the case and the stage of the trial, who is, and Lordship has remember that in case of Manish Sisodia, so while granting bail, considering the bail was ultimately rejected. Supreme Court says that court has to calculate for whose default the trial is being delayed. And if it is from the side of the accused, then that is to be deducted from that
Okay,
period.
okay.
And Lordship 436 is very clear. When law is there, whether we can.
Your submission is as 436A is there cannot be release of an accused
First, Lordship.
for a
Secondly,
period less than that,
yes, Lordship.
less than that period,
Yes.
taking it to be a long incarceration.
And
That
secondly,
is your submission.
paragraph 11 of the judgment of so-and-so, that Pallavi Ahmed Lordship.
Okay.
No, my lord.
And then 437, section rigorous of 37 will come into play.
My small response, my lord. First of all, my lord, we are not seeking bail under 436A. 436A comes off as a right, my lord. We are not seeking it as a right, matter of fact. We are seeking it on the ground that there has been prolonged incarceration, which the Honorable Supreme Court has recognized. It goes against Article 21. Even Gurvinder Singh, which my senior friend has cited vis-a-vis UAPA, that subsequently, my lord, Shoma Sen has come, wherein the Honorable Supreme Court has observed that the observations in Gurvinder Singh are not in conformity with the principles under Article 21, and it has reverted back to the position of Najib, my lord, that when there is prolonged incarceration, then Article 21 gets vitiated. So Gurvinder Singh will not come to the assistance of the NCB. That has now gone, my lord, after Shoma Sen. Now regarding Shoma Sen, my lord. Shoma Sen has come, my lord, I think 2 months back, my lord. This Gurvinder Singh came in March. This I think came in May, my lord. Shoma Sen, UAPA, my lord, same 43D5. It was in Gurvinder Singh, they said that no, Najib will not prevail. The rigors of 43D will have to be maintained. Then Shoma Sen comes in and says that no, Gurvinder Singh is not in consonance with the principles of Article 21. Go back to Najib, because Najib says that when there is prolonged incarceration, then Article 21 gets vitiated. So constitutional courts, trial courts will not have the power. Constitutional courts will have the power to enforce Article 21. So, my lord, here we are saying that
Give
since
me citation of Soma.
I'll provide, my lord, because since my learned friend has suggested Gurvinder Singh, that is the UAPA matter, I'll provide, my lord, Shoma Sen. Now, my lord, regarding for whether the incarceration of 3 years, 8 months, and 6 days constitutes prolonged incarceration or not, can be no hard and there is no quarrel in that phase that there can be no hard and fast rule. There can be no precedent that 1 year, 6 months, or 2 years, or 3 years is a prolonged incarceration. It will depend on the facts. In this case, my lord, trial has gone on for considerable amount of time. My lord, I have submitted a certified copy of the order. Well, they have been submitting that evidence has been closed. It is apparent that evidence has not been closed. It is on their prayer now that another witness is going to be examined. So, my lord, the delay here, as my learned senior friend had pointed out, this honorable court has to examine who has caused the delay. So, by bringing this witness, recalling this witness, this delay has been contributed by them. Secondly, my lord, we do not know how long this will go on. List of witnesses are 12. Nothing on record to say that they will not examine the other 2 witnesses. So we do not know. It can go on for 1 day, it can go on for 1 month, it can go on for 3 months. But every day, my lord, which I am spending which is beyond the requirement, my lord, is prejudicial to me, my lord. So that is why I am submitting. 36, why 36(1) came, why 36D came, my lord. The whole purpose was to expedite the trial. The lordship has already dealt with this part in one of your lordship's judgments, the intent behind incorporating 36(1). But now the courts are overburdened, cases are getting delayed. In many cases, defense is contributing. In some cases, prosecution is also contributing to the delay. So depending on the facts and circumstances of each case, my lord will have to examine whether there is prolonged incarceration or not. Here, this honorable court had an order that we are giving a 6-month period within which conclude the trial. Though this period was not for the purpose, as your lordship had pointed out, for conclusion of the trial, only to see that if beyond 6 months the trial goes on, the accused may be released on bail. Subsequently, when the trial went on, the accused was released on bail. This was in November. Now it is June, my lord. Another 7 months has gone, my lord. Well, I am behind bar. Primarily, the allegation remains the same, my lord. Though the judgment has been relied on by a senior friend to show a case where there are distinctions between the nature and
allegation against Shakil and you.
Shakil and here, my lord, if my lord sees the Seizure list, my lord, same allegation is there, my lord, against both the persons, my lord. Their allegations are not varied and not in variance, my lord.
Only quantity differs.
Quantity is different, but both are commercial quantity, my lord. So, in my humble submission, my lord, considering the fact that the delay has been there, trial, we do not know when the trial will get concluded, my lord. and one of the co-accused has been released on bail, my lord. So if all these factors are comprehensively examined by your lordship, my lord, perhaps this is a case where your lordship can release us on bail, irrespective of the rigors of 37.
It will open. Say paragraph 17 of this judgment, this is a full court judgment. Supreme Court has occasion to deal with Article 21. Particularly paragraph 17 deals with Article 21, legality in case of cases where non-bailable offences are there. Although it is not related to NDPS, but law has been laid down by the Honorable Supreme.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. S. C. K.R., learned standing counsel, NCB. Let this case be listed for delivery of orders on Wednesday. Wednesday is 26.
Deeply obliged. But I'm furnishing the Somasen judgment.
You give a photocopy of that
The judgment, madam.
judgment.
May not
first.
provide, madam.
I'll share.
My pleasure, Lordship. With a commercial quantity, Lordship, succeeded better, Lordship, Lordship will kindly turn to page. Kindly come to the page, Lordship, 32, Lordship. Petitioner earlier approached this honorable court, Lordship, page 32 is the order, Lordship, will kindly.
Yes.
32, Lordship, Lordship will kindly see the order dated 14/9/2023, Lordship. Down below, Lordship.
Relevant portion.
14/9/2023, and the relevant portion is on page 34, Lordship. There is a
Time limit was
observation was there, Lordship. It is however provided a learned trial court should make an endeavor to complete the examination of PW within a period of 5 months from the date of receipt of copy of this order, failing which the court shall consider the bailiff favorable to stringent condition, Lordship. This is the observation of this honorable court, Lordship, that the 5 months has been it's on February, Lordship. We have filed a petition before the learned trial court. The learned trial court rejected our petition, Lordship. They're on page 36. Is the rejection order, Lordship. And now the position is that, Lordship, all PWs has been examined, Lordship. This subsequent development has arisen, Lordship. That Lordship will kindly see.
all PWs are examined.
Lordship, now the.
Now, at what stage?
Lordship will kindly have look at this. নতুনকে আকৌ মালখানাৰ মানুহ আকৌ GD entry এইবিলাক
মাতিছে।
আকৌ মাতিছে। Lordship will kindly see the order dated 6/6/2024, Lordship. This is the subsequent development, Lordship. The Lordship will kindly see that the order at this stage, Mr. Dekka, the learned public prosecutor, filed a petition under section 311 of CRPC, paying for inter alia to call for 11 GD entries relating to seizure of contraband. So and so the transmission of the information of seizure to the superior officer, police officer, the transmission of contraband from the police Malkhana to SDM court and return thereof, the sending of the contraband through SDP office, DFL, Kalibara, Lordship. That means, Lordship, again, this person will be called for examination, Lordship. The IO, the complainant, and the in charge of the Malkhana, Lordship. This is the position of the case, Lordship. And already a passing of the orders, Lordship, already.
What order was passed on this?
6/6/2024, Lordship.
No, on this petition filed by the, whether this petition was allowed?
Allowed, Lordship.
No, it is fixed for orders on 19.
Lordship. Again, Lordship, that
Yesterday, whether this petition might not have been allowed. What happened yesterday?
yesterday, Lordship, will I have annexed the last page, Lordship. Nothing happened, Lordship. That for orders and that has been fixed.
Draw kar li?
Draw.
No, what orders was passed?
Lordship.
On 6/6, the PP filed an application under 311.
Lordship.
That was heard and fixed for orders on
Lordship.
1911.
But no order was.
Suppose this
passed on-
petition is rejected, then the case would be different case.
Lordship.
If this petition is allowed, then there may be again.
Again,
delay.
311 then.
So you have to inform what order was
So,
passed.
that last page is the order.
No, last page is the
Yesterday
status.
date was 19, so certificate copy was not possible. Lordship, we have from the.
Again, 17 has been fixed for orders.
For the production law.
No, whether that petition was allowed or not.
No, Lordship, that the verbally, Lordship, it was said to call for that, Lordship. Verbally, it was instructed.
No, verbally cannot be passed in a NDPS case.
And in
When-
verbally, court submitted, Lordship, to manage the matter like that, Lordship. As per informed by the advocate. concerned advocate,
When there is a formal application under 311,
Lordship.
some order has to be
No,
passed.
order.
No, this is not copy of the order. This is the,
No, the order passed on 16/6, Lordship.
No, but 19.
no, Mr. Munir,
Lordship.
on 16/6, the petition was filed. You have to inform this court what order was passed on that petition. The date of order was yesterday. We'll fix it on
Next week, Lordship.
Tuesday or whenever you want.
Copy to Roy, na? Certificate copy.
When should we fix it? On the request of Mr. S. Muni, learned counsel for the petitioner, let this case be listed again on 25th of June. 26th June, 25th June. Thakuk.
Much obliged.
Lordship, I have been languishing in jail for 250 days till today.
How many days?
Lordship,
How many days?
250. 250. So I would like to draw your Lordship kind attention to the 2 points of my submission. First submission that I don't have any criminal antecedent. I'm the first-
What offense is this?
It's the NDPS.
NDPS.
Lordship. This is the first offense I have which is alleged, against me. So on this ground, the Supreme Court has said that if absence of criminal antecedents, the section 37.
What is the offense?
Section 18B and 29.
What was found? What was found?
Lordship,
What is the contraband?
contraband 6.05. Opium.
Opium.
Lordship.
Okay. What is the commercial quantity of opium?
My lord, it is 2.5 kg.
2.5.
Here, what was found? 6.
Yes, my lord.
0.058
6
kilo.
point.
0.5.
6.058 kg, my lord.
Yes, now what is your submission?
My first point is that
This
And
is the first offense.
first offense, that's why section 37 can be diluted in this regard, and Supreme Court has said in this matter. And I will to buttress.
You
my
have
submission, I
authority.
will- Lordship,
You have some authority on that.
Yes.
Any judgment in support of
Yes,
yourself?
Lordship, I.
And continue your submission.
Yeah, Lordship. This is the first point. Next point is that Lordship, kindly come to the page number 17, Lordship.
You give a copy to the PP. Yes, next point.
Next point is that Lordship, kindly come to the page number 17, Lordship. Page number 17, the Seizure list, the type copy of the Seizure list, the 6.05 kgs have been recovered. I am the helper. I am not the driver. I am the second accused of this FIR. So 6.5 kgs have been recovered from 6 pieces of contrabands. But the contraband should be weighed up separately. Container and contraband should be separated and weighed like that. But this has been not followed. That means section 52A, which is observed in Mohanlal's case, has been violated. Hence, the rule 2, 3, 5 and 7 of NDPS rules 2022 has been violated. And if 52A is violated in the Seizure list, and this, then it is the Seizure list is like a waste paper, but nothing else.
Now, why 52A has been violated?
Lordship, I am giving you the rules of NDPS.
No, you read out what rule has been violated.
If the narcotic drugs, psychotropic substances, and controlled substances are found in packages or containers, such packages and containers shall be weighed separately and serially numbered for the purpose of identification. But it's not separated from the container. It's together it's been weighed up. So, sub rule 2 of rule 3 is violated. Then, so deposit of godowns, no malkhana certificate is there as per the information I have. And section rule 5, this is NDPS rule 2022, which is issued on 23rd of December 2000.
Which rule you are referring to?
Lordship, I am providing you that. Standing Order 88, 89 has been repealed, and instead of this, the rules has been newly issued.
Okay, okay.
So, Lordship, in this regard,
Then you have to read out the name of the rule. NDPS storage, Seizure, storage, sampling and disposal rules 2022.
Lordship.
That name should be
this is
read
the
out.
title, Lordship. So,
It is similar to the notification 1 of 89.
Lordship, say, Standing Order 88, 89 has been repealed. It is written in the last.
Yes, yes, that you are right.
Lordship, now I would like to draw your attention in regards of violation of section 52A in the Supreme Court's judgment in Mangilal versus State of.
No, how in this case that rule has been violated? What is the necessity? In the NDPS substances
The
are found
contraband
in
has to be
packages
separated, sir,
or
Lordship.
containers.
The contraband as well as
Such
the container.
packages or containers should
The
be weighed.
contraband as well as container has to be separated from each other, and then it has to be weighed up. But it is not nowhere it is written that it is separately weighed up.
You have gone through the inventory
Lot.
because charge sheet has been laid in this.
Laid.
So you look at the inventory and the,
Same.
you have to go through.
My lord.
They are alleging that there is violation of section 52A
Yes, my lord.
in not sampling the contraband according to the
Yes.
22 rules.
Yes, my lord.
So, and therefore there is violation of mandatory
Yes.
provisions.
My lord, that is recorded, my lord, that because of, my lord, that substance is, my lord, is daily substance, my lord, that is not separated from that, my lord, packet. And that is recorded, my lord, in the,
Okay.
when it is weighted, my lord, that fact is recorded, my lord.
But that no explanation has been given.
No, that is explanation is there, my lord.
Okay, you first complete your submission.
Sure.
He has some answers.
Lordship. Lordship, due to the violation of section 52A, the Supreme Court has said in Mangilal versus State of MP, the paragraph 5, that this is the primary evidence, Lordship. And if primary evidence is violated, that is the case will be initiated. The next one more judgment of Justice Mehta. This is in Muhammad Khalid versus State of Telangana.
You are giving copy of those judgments to me.
Lordship.
Yes.
The Muhammad Khalid versus State of Telangana in this paragraph 22.
What it says?
Supreme Court said, admittedly, no proceedings under section 52A of the NDPS Act were undertaken by the investigating officer PW5 for preparing an inventory and obtaining samples in presence of the jurisdictional magistrate. In this view,
In the instant case, whether inventories are prepared or not, that I was putting query to you. Whether inventories are prepared or not, whether sampling was done is done or not.
the Seizure list is mentioned in there. So then it is also
Because the case which you are citing, in that case, no sampling was done, no inventory was prepared. So facts are different.
completely 52, section 52A, rule 2(3) of new rule NDPS rule 2022 of sampling has been violated, Lordship.
Okay.
That's right. And if 52 is violated, then the Seizure list is nothing but a waste paper. In this judgment, it has been
No,
said.
that is true.
Lordship. Then the last but not the least judgment, which I would like to refer, this is the court Jodhpur-based judgment of Rajasthan High Court. Relying on these two judgments, the Mangilal and Muhammad Khalid's judgment, the Rajasthan High Court has enlarged the bail to the accused person on violation of section 52A, which is a mandatory violation, and this is like a fundamental rights of the Constitution of India. In the NDPS cases, the 52 is like the fundamental rights of the Constitution of India. Lordship. This is another judgment which I would like to buttress my submission.
Okay, so your submission is
two points.
containers
Criminal
and the
antecedent.
contraband were
Lord-
not separately weighed.
Lordship.
Therefore, there is a violation of
52A.
rules and accordingly violation of rule
Mohanlal's judgment also.
52A. Any other submission?
No.
And secondly, that if the offense
time
is the
offense.
first offense,
Lordship.
The
Section 37. can be-
rigors of
may be diluted.
37 may be diluted.
Lordship.
Okay. Yes, Mr. Sharma.
My lord, in the seizure list, my lord will find it in my lord, number 7, my lord, serial number 7, my lord. That is the how, my lord, details of that, my lord, seizure. And in that, my lord, it is mentioned, my lord, that because of the jelly-like substance, my lord, it was not possible to separate from the, my lord, the plastic packet. That's why, and if, my lord, some portion of weight is, my lord, less, my lord, then also it is, my lord, commercial quantity, my lord. Because it is the, my lord, well above the commercial quantity, my lord. It's a commercial quantity, my lord, it is 2.5 kg, and it was contraband was.
No,
my lord-
his submission that 52A was not followed.
Yes, my lord, that is, my lord, recorded in the, my lord, seizure list. Under what circumstances, my lord, that cannot be done, that could not be done.
Okay.
That is my lord, clearly mentioned, my lord.
And that first offense should be given
That is, my lord, I have found it, my lord, husband, my lord. And my lord, that is actually, I have gone through first time, my lord. This is the
I'm
first
also,
offense, my lord,
I'm also a
37,
doctor.
37 rigor is, my lord.
Can it be taken as a precedent?
That is, my lord. It is a, the first offense,
Unless it is written by the Supreme Court, it should not be used. We'll have to use it as a precedent. Wherever Supreme Court doesn't want, it specifically says so.
and the decision was taken on, my lord, 25/1/23. Then after that, my lord, I have to, if lordship allows me
But
some.
it was, the benefit was given considering the facts of that cases.
Yes, ma'am.
Facts of that cases.
Yes, ma'am.
It has not stated that
Yes.
in every case,
Yes.
the first offender should be
Yes,
given
yes.
laxity, that the 37 should be leniently
Yes.
enforced. So it depends on the facts of this.
Facts on the each case, my lord. And here is, my lord, from the vehicle, my lord, in that vehicle, my lord, there is the 2 person. And my lord, this is the present petitioner is the helper of the driver. So, my lord,
Present
is a
petitioner is-
conscious position is there, my lord. Undoubtedly, conscious position is there. And my lord, the status of the trial, my lord, that is, my lord, charge is framed on, my lord, 26/2/24, and evidence is yet to be started, my lord, according to, my lord, the last update of the, my lord, scan copy.
What has happened to the other co-accused?
So
You are not aware.
They have to file a bail petition.
Okay.
But Lordship, on regards to section 52, this is not only the violation of rule 3 of 3, but it is rule 5 and 7 also violated, Lordship.
That judgment I would require. That you have given a copy?
Lordship.
Okay, okay,
Yes.
okay. Mr.
M. Rahman.
This is item number 21. M. Rahman, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. Let this case be listed for delivery of orders on Wednesday, 26.
Highly.
May trigger Lordships, due to some miscommunication, we are unable to take step on time, and yesterday we have taken step, my lordship. Later matter may come on or before 28, your lordship.
Steps on?
My lord, Steps. Yesterday only we have taken step, my lordship, that's why, my lordship. To the informant.
POCSO, Lordship.
POCSO, it is POCSO.
Okay, then it will have to come after vacation.
No, my lordship, or not before 28, my lordship.
No, if you have taken steps, yes.
Oh, yes, that is. Is to register post, my lordship, already done, my lordship.
Which date you have mentioned in the,
My lord.
Raised through this, yes. PP officer.
PP. On 18, my lordship, we have taken step.
okay. Yes, continue.
Lordship, the bag which was lying beside them, it contained ganja. But they had no knowledge about the bags. Neither it belonged to them. My lord, the quantity is only 23.990 kg. The commercial quantity is, lordship, 20 kg. So they have possessed only near about 4 kg extra than commercial quantity as per allegation. Both the petitioner ladies, they came to visit Kamakya temple and both are illiterate, my lord. And the second accused, Sangeeta Devi, she has been facing eye problem who needs immediate treatment. So kindly consider the aspect, my lord. They have been behind the bars near and about 9 months. Lordship, my humble submission is that a mild view may be taken and they may be released as because they are housewives and the family has been
Any
facing.
other submission?
My lord.
It is alleged that it was your luggage. From your luggage, the ganja was seized.
My lord, this was only suspected that the bags belong to them.
You are denying that it does not belong
Yes.
to you.
Those bags did not belong to us. Lordship, both the ladies, they are from Bihar and their family has been facing much problem due to their arrest.
Yes, Mr. Sharma.
My lord, as per his inventory, my lord, it is recovered from their possession, my lord. And my lord, that trial is concerned, my lord, only for production, my lord.
Lordship, the
So, my lord, charge is not framed yet, my lord. And my lord, at this stage, my lord, it is from recovery is made from them, my lord.
Lordship, it is only suspected.
Well, charge sheet is, my lord, given, my lord. After investigation, my lord.
Lordship, we are ready to face any kind of trial. Kindly consider the aspect and when the release.
But the seizure list shows that it
Yes,
was seized from your possession.
my lord.
Lordship, the bags were abandoned bags in the station. So it has been lying beside them. So accordingly, they will be suspected of having the bags.
Okay, I'll go through the scan copy.
Scan copy, my lord, I have gone through, my lord. That is the thing, my lord.
Lordship,
At this stage, my lord. And my lord, CS is only, my lord, dated, my lord. CS is furnished on 13/12/2023. And thereafter, my lord, this 6 month, my lord, the production there.
Lordship, the second accused, Sangeeta Devi, as I have
Last date
mentioned,
was, my lord, 8/5.
she has been suffering from severe eye problems. So
Okay,
she
we'll
needs
direct-
treatment.
Direct her to be treated properly.
That is taken care of, my lord, because, my lord, lordship will find, my lord, there is just 2 or 3 orders, my lord, for his treatment, my lord.
My lord,
Honorable,
kindly-
honorable trial court, my lord,
No, you don't have a case.
necessary order,
We're ready
necessary
to
order
face
regarding
any
that.
kind of trial in the trial court.
No, you don't have a case. I will go through the scan copy and pass the orders in chamber. Your prayer is likely to be rejected.
My lord, kindly consider the aspect of your
I'll
families.
consider everything. You go through the order after some time. Tomorrow you go through the order. Chamber.
Much obliged.
My business.
Yes.
My business. Lordship, it is a substituted case, Lordship. I am behind her for bar for 1 year, 6 months and 2 days, as on today, Lordship. But till today, Lordship, not a single witnesses has examined, Lordship. It is 1 year, 6 months, 2 days. Not a single witness has examined.
Last 12/6/24
Yeah.
was fixed for evidence, that what
Yes,
happened?
What happened on 12/6?
I have the order, Lordship. May I read that portion, Lordship? On 12/6 orders, Lordship.
12/6.
Yes, no, I have.
Did you?
You read it.
Yes, what should I do? On last it was fixed on 12/6, then it is, next date was is 8/7. I have highlighted that today the matter is fixed for prosecution evidence. However, no witnesses is present as prosecution has failed to take steps. After the next case, Lordship, the next date is fixed on 8/7/24. Lordship, till today, not a single witness has been examined.
But whose bail petition is fixed for hearing?
Lordship, one co-accused, one co-accused Ali Hussein, he was enlarged on bail, Lordship, by the trial court below. That was fixed, he was enlarged on bail, Lordship, I have not annexed the order, but I made a statement, Lordship, on 19/1/20, on 19/1/2023, he was enlarged on
How many accused are there?
3.
So Ali Hussein was,
Only Hussein was enlarged on bail, Lordship. But he was enlarged on bail on 19/1/2024.
but 18/6 was fixed for hearing on bail petition.
For another, as per my knowledge, for another accused, also for another accused, bail petition was filed, Lordship. That is Mehdi was, what? For Mehdi. That was also rejected, Lordship. It is available in the report orders. It's available, but only Ali Hussein was allowed.
What was the contraband?
It is Ganja, Lordship,
How much?
around 40.680 kgs.
Yes, Mr.
Yes, Lordship, charge frame, my lord, on 5/1/24, 5/1/24. Thereafter, 2-3 occasion, prosecution witness not present.
Not routine, several days, on several occasions.
Date of arrest is 12.
Date of arrest is, Lordship, date of arrest is like, 18/12/2022.
Any submission, Mr. Kogoi?
Chief, it is only that detention period, my lord, otherwise that 37 and above 37 will come, my lord, because it's commercial quantity.
For this purpose, Saiful Islam is here, Lordship, and another order passed by this honorable court, where elaborately discussed by this honorable court in that order, reflecting all the citations.
What is this?
Order of this one.
Yes, sir.
Page, power 30, Lordship. Relevant to my case, power 30. Power 30. Paragraph 30. It is also pertinent to mention herein that the Supreme Court of India had granted bail to the accused facing charges for possession of commercial quantity of contraband only on the ground of prolonged incarceration in Shariful Islam alias Sharif versus State of West Bengal.
27. 26th. Heard Mr. For delivery of orders. Heard Mr. E.K. Soharia, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Fix this case for delivery of orders on 26.
Deeply obliged, sir.
Bail orders কিমান আছে? চাৰিটাত কি আইটেম নম্বৰ কিমান আছিল? কিমান? Number. Item number 41 we will take up after, because we have not yet completed hearing met and this bail hearing.
Oh, that was mentioned by somebody.
Though it was mentioned,
Yes, I'll mention.
you are from outstation,
Yes, Your Honor.
but bail hearings are urgent.
Of course.
You have to wait for some time.
We'll wait. I'll try to summarize as early as possible.
Okay.
Maybe 15 minutes. I'll take 15 minutes to conclude my side.
Then we'll take it up at 4:30.
Okay. Your Honor may have it, just give me a little bit of scope, 15 to 20 minutes. I'll be more comfortable.
Okay, 5 minutes I will sit extra.
I'm so obliged, highly obliged. Yes.
May it please, Your Lordship. Actually, it should charge sheet at
4:30 mati go to hearing. Hearing to 4:30 mati.
C no hoto.
Yes.
Charge sheeted matters, Lordship. I was arrested on 12.
What was the
2024 in connection.
contraband? How much contraband was it?
Contraband is 9 kilogram ganja, Lordship. 20B.
Why it was rejected by the special judges?
Lordship, because of
Where is the rejection order?
last case, Lordship. Lordship, last and exam.
You tell me the page number.
Case number 18, Lordship. Last para, Lordship. Considering the nature and gravity of offense and the fact that the matter is at the stage of.
When
criminal
were you
charge.
arrested?
Lordship.
When were you arrested? Date of arrest?
12 February. 12 February. Lord.
How many days you have completed?
As on today, Lordship, 129 days.
129. How?
That is 4 months. With this.
In the meantime, statute
Oh,
submitted.
charge sheet has been submitted. Okay. Yes, Mr. Go.
Yes, my lord, size frame on 1/6 and 25/6, it is fixed for evidence. That is this piece.
What is your submission?
Lordship, I am a student of class 12 of Patna.
No, merit you,
College.
merit of
Lordship, and my maternal grandfather expired on 24/5/2024, Lordship. And I could not attend the funeral ceremony, Lordship. And my humble prayer to allow me to go on bail on any terms and conditions, Lordship.
Now, regarding the accusation, what is your submission?
Lordship, Lordship, I was traveling from Agartala.
This is item number 27.
Patna.
27, yes. Is a resident of Bihar, my lord.
So when I reached Guwahati railway station, some
No, what assurance will you give that if you are released on bail, you will appear before trial court regular?
on any terms and conditions, Lord Ship,
No, every accused say so. But what assurance will you give that you will regularly appear?
as per your lordship, in any condition.
Okay. Heard, Mr. What is your name?
BLE.
BLESK.
B. Ali Sheikh, learned counsel for the petitioner. Also heard Mr. B. Goswami, learned additional.
Gogoi.
Sorry. B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Vicky Kumar, who has been detained behind the bars since 12/2/2024, within bracket for last 129 days, in connection with special NDPS case number 139/2024, corresponding to GRPS case now. GRPS case number 42/2024 under section 20B2B of the NDPS Act, 1985, which is pending before the Court of Learned. Which court it is pending?
Additional district session just number 3, Kamrup Metro.
Before Learned Additional Sessions Judge number 3 within bracket FTC, Kamrup Metro, Guwahati. The gist of accusation in this case is that, where is the affair?
Affair in page 12, Lordship.
That on 12/2/2024, one Pranamika Bormon, ASI of Government Railway Police, Pandu, lodged an FIR before the officer in charge of Guwahati GRPS, inter alia, alleging that during the routine train checking duty on 12/2/24, when train number 01666 DN Rani Kamalapati special fare train was standing at platform number 1 of Guwahati railway station at about 7:40 AM. The present petitioner was found in possession of 8 numbers of packets wrapped in brown color sellotape containing suspected ganja. On weighing of the recovered ganja, it was found it weighed 9.143 kgs. On receipt of the said FIR, GRPS case number 42/24 was registered and investigation was initiated. Ultimately, on completion of the investigation, charge sheet was laid against the above named petitioner under section 20B2B of the NDPS Act, 1985. What is your submission regarding?
Lordship, under the same section, the charge has been framed.
Learned counsel for the petitioner has submitted that the petitioner has been facing an accusation under 20B2B, for which charges were framed on 1st of June 2024. However, he has not been released on bail, though there is no embargo on his being released on bail, and the trial court has only rejected his bail on the ground that the offense involved is in where is the rejection order?
Page 18, last paragraph. On the ground that the matter is at the stage of framing of charge.
On the ground that the matter is at the stage of framing of charge and considering the nature and gravity of the offense, the affair was rejected. Stop. Learned counsel for the petitioner submits that though the petitioner hails from Bihar, he would face the trial. He would cooperate in the trial and regularly appear before the trial court as and when so required by the learned trial court, On the other hand, what is your submission, Mr. Goswami?
Some stringent condition may be given, because he is from Bihar.
On the other hand, learned additional public prosecutor also submitted that as the petitioner is from Bihar, there is an apprehension that he may not turn up if he is allowed to go on bail. And therefore, if he is allowed to go, in case he is granted bail, stringent conditions may be imposed. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the scanned copy of the case record of NDPS case number 139/2024, which was called for in connection with this case. As the petitioner was found in possession of only 9 kg of ganja, which is of intermediate quantity, and as he has already undergone detention period for 129 days, this court is of considered opinion that if the petitioner cooperates in his trial, his further custodial detention may not be necessary. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount. The surety should be a permanent resident of the state of Assam with following conditions. Condition number 1 to 6. 6 conditions. This bail application is accordingly disposed of.
I've checked that the order sheets as well. There are only 2 witnesses examined till date that he has also annexed in his petition. And of course, the order sheet is not there. What had happened is these people the petitioner was arrested way back in 21. And few other accused persons.
Date of arrest is?
Date of arrest is
12/10/21 and 14/10/21.
12/10/21, 14/10. The other co-accused persons were declared absconders. And so his case was splitted up. Now the trial is going on, but then only 2 witnesses were examined. Lordship will see the last order, 2023 order, where the case was split up because of the delayed trial. Page number 32, the order is there. The order was of 2nd of November 23.
Okay.
Lordship will see the last but one paragraph. Seen petition for Runa Lela there, granting
Now,
bail.
what was the contraband? What was
This is tramadol.
tramadol?
The capsule, Lordship.
What capsule?
Simplex.
How much?
420, no, 4,000. 6048 capsules, 42 packets.
42 packets.
And the FSL report is some 25 point something gram per capsules. Per tramadol. Lordship will find that FSL
What is
report
the weight of the seized contraband?
that is not reflected, the entire tablet weight.
Lordship, and there are contradictions in the statement of the witnesses.
No, what is the weight?
Wait, not
They're not measured. I mean, I couldn't get in the
Only-
FSL report.
In
Or
the
it is-
inventory?
Lordship, only one.
Inventory is there. It is in the case records. No, only per capsule tramadol is so much. But police are-
What was the weight, Mr. Rana?
No,
41
Seizure is
something mg per capsule, Lordship.
that is FSL
That is
report.
the,
That is the
that is the FSL report.
We have 420 packets.
42 packets.
No, 42 packets.
6,048 capsules.
Even in the Seizure list, that weight thing is not there. 329.
Only examination results shows that 48.50 mg.
No, you don't look at the FSL report. You look at the inventory.
Inventories. That inventory report is there in the, I can see the case record,
Yep.
isn't that, eh? But on a first blush, I couldn't get that weight, the
How many days it comes?
3-4 years. Come on.
2 years, 8 months, Lordship, and 10 days, as on today.
Luta.
Otherwise, they are detained for long. When the charges were framed?
Charge, 2 witnesses were examined and charges were framed.
Charges were submitted on 10/1/2022, Lordship.
Charges?
Charges are framed on November 23, November 23rd. And 14/12/2023 was the first date for evidence production. There are 13 listed witnesses there, Lordship. Only 2 witnesses have been examined till date,
Out of 13.
out of 13. And their statements are also contradictory, Lordship.
Contradictory, we cannot say it now because police is yet to be examined. Now
No.
here,
Informant has been examined, Lordship, and one
No.
eyewitness was also.
Now, on what ground you are pressing? Long incarceration. On what ground you are claiming bail?
On
No
the ground of
materials.
incarceration, Lordship, only 2 years, 8 months in jail, Lordship.
Okay.
And
Anything?
Lordship.
Any submission?
Yes, 2 witnesses were already examined. First witness, of course, he had not said anything about. He is the bus driver, and he said that the conscious possession is proved by his deposition, because he The bag was in fact, I mean, recovered from his possession, but like, it was in the dicky. It was in the dicky, but,
It was in the side dicky, Lordship,
hmm.
outside the bag, it is a side dicky.
Okay.
But then
Third,
he claimed
Mr.
the ownership
I'm
of the bag.
Fix it, I'll fix a date for delivery of order. Heard Mr. M. Rana for the petition, also heard Ms. S. Jahan, learned additional public prosecutor. Let this case be
In a
listed
similar
for
case, in item number 18, your Lordship has already granted bail. In a
today.
similar- Lordship.
Similar or same?
Not similar, not same.
Today, all cases are similar. On 27,
On any condition, Lordship.
27 for delivery of orders.
The order sheet after the examination, after this order that he has annexed, it's not there in the case record.
What was the last order?
The one that he has annexed was on November 23, no?
Rejection order by the.
No, splitting up,
Splitting up and rejection both.
splitting up and,
Now, what is the, how many witnesses have been
Till
examined?
date, 2 witnesses have been examined out of 13.
That I can record in the order sheet.
Till date,
2 witnesses are there in the
But it is
record.
not updated.
The order sheet, I don't find it here. After, order sheet is only till 22, 26/5/22 and
And
nothing.
here, yesterday was fixed for evidence, Lordship, but whether evidence has been examined or not, I have no idea. Just yesterday.
Order sheet
And
pertaining to the year 2023 is not there in the records.
next case was fixed on 2nd July. As reflected in the e-court.
No, you have to inquire what happened yesterday. Because you are making submission today.
I have inquired, Lordship, no witness was examined.
No witness. Now, you just now said that you don't have any idea. You said that I don't have any idea what happened yesterday.
Lordship.
Now you are saying that, no.
That is informed by my colleague, Lordship, but I have not personally.
Let the updated records come along with the order sheet of the year 2023.
Yes, because in the meanwhile, if the
Hmm.
witnesses are examined,
But the last witness was examined in 24 itself. He was examined on 4th
Okay,
of March
okay.
24.
heard Mr. M. Rana, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. It appears from the scanned copy of the case record which was called for in connection with this case that the same is not up to date. And the last order which is available on record is of the month of November 2023. Let an updated status report of the special NDPS case number 2/2022 be called for from the which court?
This is Session Judge Baksa,
From the
District.
Court of Learned Session Judge Baksa. Let this case be listed again on when?
27, Lordship.
27. On 27/6/2024.
The last order was not of November. It was 9/6/2022.
9/6/20.
23/6/2022.
Last order available on record is of
23/6.
23/6/2022.
The last order sheet or.
Oh, that's good. I have annexed the order
Ah.
for second
Second,
November 2023, page 32. I have annexed.
whereas order dated 2nd November application. However, what has happened thereafter is not on record. Officer. Okay, 27. Yes.
Lordship, the charge-sheet case, Lordship, the charge was framed on 5th December 2023, Lordship.
No witness was examined till date, Lordship.
Trial
The
started, summons were issued to the witnesses, but they have not appeared.
petitioner is the helper, Lordships.
When you were arrested?
Lordship,
It's 23.
6th April 2023, Lordship.
6th April 23, yeah.
1 year, 2 months, 15 days, Lordship. Helper, Lordship. I have no knowledge about the.
Not a prolonged incarceration.
And what are your grounds? On what ground you are?
Lordship, I have no knowledge about the case, Lordship, 17 Lordships. There are 8 circumstances of the seizure, Lordship. The suspected heroin and the Uber tablets were concealed in the driving chamber inside left and right side of the.
No, you are just denying. You were the driver,
No, Lordship, helper, Lordship.
helper.
I have no knowledge, Lordship, about this.
Apart from that, no knowledge, any other submission?
The Lordships. On the length of detention.
Length of detention is not so long.
Mm.
And they intercepted the truck and both these persons, Safikul and Nurchan,
No, sir.
they were detained, they were arrested along with the articles.
No, Mr.
This is heroin.
Mr. Ahmed. Rejected.
Fixed on next week, any day.
After rejection, how? Because you have completed only? No, at
What?
this stage it is rejected.
After
Right, the-
vacation. After
No, you
vacation.
have to make your mind clear before you make submissions,
After vacation.
not after vacation.
The fixed on 28th is June for evidence.
Okay. After vacation, what will happen?
By that time, Lordship can call for the updated case records. If some witnesses have deposed and he is not involved, then Lordship can consider.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. S. Jahan, learned additional public prosecutor. It appears from record that the NDPS case number 126/2023 was fixed on 14/6/2024 for examination of prosecution witnesses. However, what has happened on 14/6 is not before this court, neither the counsel could inform this court. Hence, let an updated status of the NDPS case number 126/2023 be called from the learned trial court. Let this case be listed again on after vacation, 23rd July.
Diploma.
My lord, almost 1 month, 28 days in custody, my lord. The offense is that, my lord, he has submitted a forged
You are behind the bar for 28.
28 days, my lord. 2 days police remand was sought. And thereafter, neither any police remand sought nor any permission for further investigating. He is in judicial custody, my lord, for last 28 days. The allegation in short is that, my lord, while submitting a bail document, my lord, some forged document were submitted by a bailer in a court. That is the allegation, my lord. All documents which were submitted were being, my lord, seized.
No,
Now, whether 468 is made out or not, my lord, those are matters of trial, my lord.
whether further detention in any ways is going to further the cause of investigation, my lord. That's my limited point, my lord.
What is the progress of investigation?
That's
Yes, my lord, some other co-accused not appearing, my lord, before police, my lord, 41 notice issued to some other co-accused, my lord. That is
Now, what are the materials against the present petitioner?
materials, my lord. He has admitted, my lord, he is helping that procuring those first document, my lord.
Now, whether his detention is necessary?
Detention, my lord. So far, he is concerned, my lord. He has already been thoroughly examined by the IO, my lord.
Heard
Yes,
Mr.
the
M.
co-accused is,
Vishwas,
my lord, MD.
learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mir Ali, who has been detained behind the bars since 23/5/2024, within bracket for last 28 days, in connection with Pan Bajar PS case number 105/2024. The gist of accusation in this case is that on (15/5/2024), the bench assistant of the Court of Learned Additional Session Judge within bracket FTC number 3, Kamrup Metro, Guwahati, had filed an FIR before the officer in charge of Pan Bajar Police Station, inter alia, alleging that
in fact an order passed by the special judge number 3 Kamrup Metro is being treated as an FIR. That is at page number 10.
what is the gist?
My lord, the gist is that while accepting a bail bond in an NDPS case number 39 of 2021, one condition was that one of the bailer would be a government servant. The government servant documents which the bailer have submitted is of Guwahati University. So he suspected that probably these are not genuine documents. He called for an inquiry. He has ordered for an inquiry. The inquiry revealed that the documents are not genuine. That's the gist of it.
You were that bailer.
No, my lord. The allegation against me is that I have helped the bailer in arranging the document.
Literally alleging that while submitting bail bonds,
Bailer name is Deepu Das. Deepu Das.
He is absconding.
bail bond. In which case bail bonds?
NDPS case number 39/2021.
In NDPS case number 39/2021, where one of the condition for grant of bail to the accused was that one of the bailer should be a government servant. It was suspected that the documents submitted by the bailer who projected himself to be the government servant were forged, and on inquiry, it was ultimately found that the said bailer had produced fake documents. And the present petitioner is accused of helping procuring the said fake documents. Learned counsel for the petitioner has submitted that. What is your submission? That the petitioner has already undergone the detention behind the bars for last 28 days. Any other submission?
No, my lord. And all relevant documents have been seized, my lord.
And the relevant documents have already been seized from him. And under such circumstances, his further custodial detention may not be necessary. It is also submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor Mr. B.B. Gogoi had produced the case diary of Panbajar PS case number 105/2024 and has submitted that though the investigation could not progress could not be completed due to non-cooperation by one another co-accused who has not appeared before the investigating officer in spite of issuance of notice under 41A to him. However, as regards the present petitioner, the investigation has been substantially progressed and his statement under section 10161 of the Code of CRPC, Code of Criminal Procedure has also been recorded. Stop. I have considered the submissions made by learned counsel for both the sides, as well as peruse the materials available on record, including the case diary of Panbajar PS case number 105/2024. Stop. Though there appears to be some incriminating materials against the present petitioner in the case diary, however, considering the fact that his statement under section 161 has already been recorded, and also considering the period of detention already undergone by him, his further custodial detention does not appear to be necessary if he cooperates in the investigation. Stop. In view of above, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned
Chief Judicial Magistrate, Kamrup Metro.
Kamrup Metro, with following conditions. Condition number 1 and 2.
I'm deeply obliged.
You also got it because time is coming. I am at item 33. It may not reach today, madam. Let it be next Monday, madam.
Next Monday.
Because 41 item you also will take with the upgraded program.
33.
33.
On request of Mr. H.R.A. Chaudhary, learned senior counsel.
24 now.
Appearing for the
Monday or 24.
Let this matter be listed on 24/6/2024.
24/6.
Item 37, Lordship. Can it be taken on Wednesday, Lordship, next week?
37 witness.
There is an intermodal, Lordship.
Intermodal self-contained.
With regard to item number 51 of the supply list, my lord, it's a bail matter, my lord. Yesterday, my lord, instruction was to be obtained as to whether 30 are submitted or not. Already 58 days, my lord.
Okay, I'll allow.
Madam.
I'll allow that. 58.
Hello.
58. Item number
51.
51, 30,000 with one surety of like amount. 51. Yes.
Yes, may I please, my lord, I beg to mention item number 46, my lord. Is the matter on
The time will be consumed in mentioning.
Yes. So let's
Yes.
Yes, my lord. I'm so obliged that my lord has taken out time for this matter. I'll just be very, very concise.
Who is on the other side?
Mr. Border.
You have made your submission.
Yes. We have almost completed, Lordship. On the last occasion, if I may, I had argued substantially. So I'm just going to endeavor to conclude my arguments.
This
That-
is that what was the case between sister-in-laws?
Yes.
Yes, yes.
That is
that-
Oh,
that
oh,
is
yes,
the
yes,
case, ma'am.
Yes, yes. Yes.
Yes, at page number 140. On the last occasion, my lord had made certain observations. So I'll just address those observations. At page 140 is the complaint, which is forming a part of Annexure 12. It starts at page 141.
One
141, forming a part of Annexure 12.
Yes.
This is the complaint. At pair number 4, I'll just read the relevant parts, that is 4-5 lines. At pair number 4, I state that there were 4 number of directors in Rahman Properties Limited, and they were Adilur Rahman, that is the deceased brother, and the husband of the petitioner. The complainant, that is myself, 1 Sajid Hawk Maulong, and accused number 1, who is the petitioner. And each of the directors had shares in Rahman Properties Limited. So it is the case that at that point in time, my lord, there were 4 directors having shares. It had come from the petitioners that the accused number 1, that is the petitioner number 1, was not involved in the business. If my lord recollects, I had showed this one document, that is the annual return, wherein it is clear that the accused number 1 has been a director since year 2004. If my lord wants me to directly point out to the page, it is at page number 215. So it might not be a correct position that she did not have role to play prior to the demise of the husband. At page 215.
So your submission is that she was also actively
involved
in the affairs of the company.
Yes, since year 2004.
And she knows about the transfers of shares.
In fact, she is the beneficiary, which is the reason it is my case that all of this has happened at the behest of the accused persons. And this I will try to bring about by highlighting 2-3 pages from the annual return that was filed with the Registrar of Companies. So this page number might be of relevance at 215 to highlight that the date of appointment is 8/10/2004. My lord has taken a note?
Yes.
Yes. Now coming back to the complaint case at page number 141 again, I'll read the next part. Or for the convenience of the court, I should rather just summarize. There were 2 tranches. 2 tranches. 1, shares amounting to 218,100. 1 tranche was transferred in the name of the accused number 1, that is the petitioner 1. And another tranche of 8,400 shares was transferred in the name of my niece, that is the daughter of late Shri Adilur Rahman and the petitioner number 1. This, my lord, will find at page 143, that is 2 pages thereafter. At para 9, I had highlighted. Yes, that it may, my lord has it at para 9, that is page 143.
Yes.
I've drawn up a table, in fact, that it may be pertinent to mention here that Adilur Rahman, the husband of the accused number 1, died on 13/11/2012. This date is of importance. The shares of the complainant were transferred in the name of accused 1 and 2 as follows. So there is 1 tranche that was transferred on 5th January 2012. So this transfer clearly is happening during the lifetime of Adilur Rahman. Although I'm not admitting, but I'm just saying on the face of it, it so appears from the annual return of shareholding that this transfer of 218,100 shares was done, allegedly done, on 5/1/2012. And the second set of shares, my lord, 8,400 was done on 7th December 2012. That is after the demise in November. That is 24 days to be precise. Now, if I may be permitted to directly draw the court's attention to the annual return of shareholding.
At page
At page
215.
213 it starts. This is the annual return of shareholding for the financial year 2012-2013. So if my lord is pleased to see page 225, that is the second last page of this annual return. 225. First, I'll show 225, then I'll come back to 216. 225. At 225, my lord has it.
Yes.
This is part 6 of the annual return. So this is the statutory compliance that is done by the company. So this talks about part 6 again, the top line. Details of shares, debentures, transfer since date of last AGM, or in the case of the first return, at any time since the incorporation of the company. So this is after the last annual general meeting that had happened. So this clearly states about the transfer that has happened in the last financial year. If my lord has the first part, Niloufar Rahman, that is the transferor's name. My lord has it?
Yes.
And the transferee's name is mentioned as Afroza Rahman. Now, number of shares transferred is 218,100. Now, the important date is 5th January 2012. So this is the date of transfer of 218,100. 5th January 2012, when my brother was alive.
Yes.
So this particular transfer that had allegedly got affected on 5th January has relevance at page 216. At page 216 is my current standing as Dr. Niloufar Rahman. What is my current standing is at page 216. I am a director. Number of shares, my lord has it, page 216, Niloufar Rahman. Father's husband's name, Abidul Rahman. It is in the middle of page 216. So the transfer that had got affected allegedly on 5th January has led to a reduction of my shareholding, which now amounts to 8,400 shares. So in this financial year, my shareholding has come down after this alleged transfer of shares to 8,400.
Okay.
Now directly coming to the second tranche, that is 8,400 that I'm left with, I am again being manipulated to some extent because this transfer of 8,400 shares takes place in the next financial year, which my lord will find at page 227. At 227. This is the next financial year. And one interesting fact before I draw the court's attention to page 227, at page 226, the signatory to the annual return of the last financial year, 226, it is Afroza Rahman, director, and Adilu Rahman at 226.
Okay.
So it is my case, my lord, that Mrs. Afroza Rahman was very much a part of that particular transaction. She had ratified it, signed in, and she is the beneficiary of this transfer. The transfer to the extent whereby my shareholding has now got reduced to 8,400. Now, the second part, which has happened after the demise, I will also come to that at page. Yes.
What this
annual return of shareholding.
Annual return show it is only a document what transaction occurred during the financial year.
Please. The date is important. I'm only on the date.
By the virtue of annual return, no transfer has been.
Not at all. I'm only trying to highlight the date of this transfer.
Okay.
Because when annual return is filed, any transfer that had taken place in the last preceding year is reflected in the annual return.
Yes.
So I am trying to say for my lord's consideration that this transfer took place on 5th January 2012, allegedly, although I'm not approving it.
When your brother was alive.
Yes, my brother was very much alive.
Okay.
Now, the 8,400 shares takes place in the next financial year at page 227. This is FY financial year 2013-14 at page 27. It starts. Directly, I would like to draw my lord's attention to page 240. That is the second last page again, 240. This also caters to part 6. That is the transfer that had been affected in the last preceding year.
Yes.
My lord has 240.
Yes.
In fact, the start of the page itself will highlight the situation for Nilufar Rahman. Having transferred the shares to Azana Rahman, that's my niece, my lord may see the date, 7/12/2012.
Yes.
7 December 2012. So the transfer was not done on 5th of January. The byproduct at page number 17 and 21, which I am repeatedly trying to emphasize, are the byproducts of forgery. The share transfer certificate, my lord, at 17 and 21 page number is of no consequence, because the only consequential document is the statutory compliance that will take place, which according to them had got transferred part 6 on 7/12/2012 after the demise of Adilur Rahman. My lord may see the next page, the signatory to this particular annual return.
No, but share gets transferred by way of share transferred document at seven page number earlier pages.
17/21.
17 and 21.
It suggests 5th January 2012 for both of the share
Yes.
transfer certificate.
Yes. For Azana Rahman also.
Yes. But this is the case that we are trying to bring home. That is a fabricated document having no relevance, my lord. The only relevancy would be the statutory compliance that was done not by anyone else, but by the same person. At page 241, my lord will see who are the signatories to this document, Afroza Rahman and Sajid Haq. Because by this time, Adilur Rahman has since passed away.
Okay.
So this is my limited point, that any such document that is executed in the form of share transfer certificate does not automatically go as a document. It is an option to attach it with the annual return or to not attach it with the annual return. But the entire gamut of the reality would lie in part 6, how the compliance has been done. Who are the signatories to that compliance? So there is no question of the second tranche having got transferred on 5th January 2012, which as per their own document having filed with Registrar of Companies is 7 December 2012. The case of the complainant is consistent. It is a case where the learned trial court has rightly taken cognizance. And my lord, the reality, truth will all come at the stage of trial regarding all of this fabrication that has happened behind my back. It is my consistent stance that I have not signed any share transfer certificate. I was not involved in the day-to-day affairs of the company, and I had reposed all of the trust and confidence upon my brother. But it so happened that even after my brother's demise, there was certain manipulation that took place wherein my remainder shares of 8,400 was abstracted, taken away in the name of my niece. And all of this came to light, my lord, in 2014, when a succession petition was since filed by the petitioners. And that is when I got to know about all of this alleged transfer. I might not be actively involved, but that in no way will destabilize or have less value regarding the shares that I was having of the company.
Okay, your submission is that the share transfer forms, which
page 17 and 21,
17 and 21,
both will have the same date, 5th of January.
Yes.
There
the
is some
second
stamp.
Let us come to second one, because as regards first one, you have.
I'm
you
not
have noticed-
validating it. I'm just saying that it appears that
But-
that
but-
particular date,
In case of second, that is in the name of your niece. Niece name is Azana.
Azana Rehman.
It shows that it was presented before the registrar of companies on 18/1/2012.
In my respectful submission, this is just a stamping, internal stamping of the company. So this really does not have any bearing. The only bearing will be the statutory compliance that happens. Every year, the company is bound to file their returns. Whatever is filed. In fact, there was a wrong filing. In fact, let's understand, for the sake of argument, there was a wrong filing. Has it been recalled till date? That particular filing that was done, duly signed by Mrs. Afroza Rehman, has since attained finality now. It is their own case, their own submission, their own filing with the registrar of companies that the first tranche was done on 5th January 2012. The second tranche was done on 7th December 2012 after the demise of my brother, Adilur Rehman. I'm so obliged.
One query, Mr. Bora.
My lord.
This regarding that discrepancy,
No, my lord,
your
this-
return.
This is an absolutely the new proposition, my lord. I have for the first time I have come across how in a complaint case can be developed in a later stage with some new document, which is not the environment in the complaint.
Okay, that
The-
annual return is not there.
No, nothing. Their whole case is something else. It's a new case has been built up today. This is the whole complaint case. It is their case. That is, I am surprising now. They say those document, they are not allegedly. This is your document. You said by virtue of this document, it transfer
And the
transfer has happened.
transfer deed
Yes.
forms at page 17 and
Yes,
21.
their own original case.
That they have annexed with. the
Yes, the complaint, they have exhibited. Kindly see the evidence of the prosecution PW1. Their cases by virtue of these two documents, the all share has been transferred from her name to our names, to the petitioner's name. That is her original complaint. Now, how they can develop? It is an absolutely afterthought, and this is not permissible in a complaint case. This is an absurd proposition, my lord. Tomorrow they will come out with another proposition. No. This is complaint case. They have to go by the whatever the apartment, whatever the document they have relied for taking the cognizance. That's all. The prima facie. Now, can they change at the later stage, which is not their document at all during the filing of the
But
complaint?
during your submission also, you made somewhere, I remember.
Yes. This is
the share were effected after the transfer to the.
maybe, my lord. That share may be transferred subsequently. But in their case, what is the original case? That these two documents are fake. Their original case is that we have not signed it. This is not my signature. And their case is that we don't know who is sick. And the allegation is that everybody, their own statement, their own witnesses said that during the lifetime of the own brother, share got transferred to our name. Now he has changed the gamut of the whole case. Now it is an afterthought. Tomorrow he will come up with another plea with another document which has not been exhibited, not part of the complaint. How can the court can take cognizance of that document, which is an afterthought? This is not the avertment on the basis of this. And he said that they came to know about this at the time of the filing the succession. Then why in the complaint case it is not averted? Why they are silent about it if they came to know about the fact? Their case is totally different, my lord. Succession case, they came after that, they filed the complaint case after the succession case.
Just a small rebuttal to
So,
that. Once my learned senior colleague is.
my case is, so I need some time. This is a total, if the lordship allows me, I need to see because the whole case is different.
So you want more time?
10 February. If the lordship permits, I can continue. My whole case
No,
is
it will
that.
be, then we will continue tomorrow.
Please.
Yes. Only my case is there. What is the original
No,
case?
not today, not today. I have lot of work in my chamber.
Okay. Then tomorrow, my lord, what is the original case and how they have deviated? That I have to show it to the lordship because a new fact has been brought in, which is not part of the complaint.
Then tomorrow we will fix the case at. How much time will you require?
Just 10-15 minutes. That is, I have to show that how they have deviated from the original complaint and what are the statements made before the court.
4:30.
4:30, my lord.
Huh.
Can be late, my lord. 4:30 is a difficult proposition. That's after the court hours, my lord.
No, 4 is.
Then it goes up to the 5 also. It
No, you
takes some
need
time.
only 15 minutes. Court is up to 4:45.
That's why, my lord, he'll take, then it will go after.
No, I'll not give him.
My lord, just small, like.
Then let him complete today.
Yes, just 2-3 points in rebuttal to my learned senior colleagues'
Then,
arguments.
my lord, my only case is that tomorrow, 10 minutes, my lord, I'll just show what is the original complaint, how they have deviated, and what is the statement they have made before the court on oath. Our own
No,
statement.
no. How much time both of you will require? I am not hearing it today.
I need half an hour then.
Half an hour.
About 10 minutes. Only limited to the rebuttal. Nothing
No,
else.
the difficulty is that this court is taking bail matters. So if we fix hearing matters,
Any day, I have no urgency, but I need to show that because it's a new thing has been developed. It's a new, lordship has to decide on. Either lordship has to reject that. Because that document
Next
per
week-
se.
next week any day,
Monday, my lord.
Monday. Monday, Tuesday,
Monday is fine.
okay, heard. Mr. A.M. Bora, Lanet. No, heard Mr. What is your name?
Endas.
Heard Mr. Endas, Lanet Counsel for the respondent as well as reply given by Mr. A.M. Bora, Lanet Senior Counsel, assisted by Mr. A. Bora. The hearing remained inconclusive as due to paucity of time, same could not be concluded today. Let this matter be listed again on
Monday,
24/6
Part.
at Parthad matter. As Parthad.
If a time be fixed, we will accordingly.
No, we will give you half an hour time.
Obliged.
I'll only restrict myself to the rebuttal, nothing else. I have concluded my arguments otherwise. So obliged.
My lord, probably all have a common prayer, my lord. The leftover matters can be fixed on Monday or Tuesday.
My matter is not my lab, this will be after vacation,
My
hearing,
matter, I
48
think,
man.
39.
That Arunachal matter.
39 may be fixed on Monday or Tuesday, my lord. Any 24.
The court master has to help because Monday, Tuesday we have already fixed.
My matter may be fixed after vacation, that hearing matter.
I am not giving dates.
Yes, ma'am.
You,
If your lordship give this, my lord, convenient for us, my lord. Otherwise,
after vacation.
after vacation, any date. your lordship.
Item
Item number 48, no more delay.
Item number 48.
48 right now?
Due to paucity of time, this matter could not be taken up. List this matter after vacation.
My lord, item 53.
On a date to be fixed by registry.
My lord, item 53, my lord, diary is there, my lord, so let the matter may fix on that day.
Monday কি মান আছে? Item number
27.
53 on Monday.
My lord, my item is
Paucity of time.
39. 39 CD is there, my lord.
Item number 39.
Yes, ma'am.
39 on Monday.
My lord, item number 46, my lord, list on 27, my lord.
46, 27.
27.
My lord, supplementary item number 52, bail application. today, it was not, can it be taken up on Wednesday, my lord? Bail application.
Fresh bill.
Yes, my lord, hearing matter. Because Lordship, day before yesterday asked us to find out some medical issues are there, my lord.
Okay, okay, that issue.
That issue, my lord. Wednesday, my lord, because
Okay, Wednesday. 43,
52, my lord, supplementary.
52, Wednesday.
Wednesday.
Well, regarding,
Yes,
well, regarding item number 36, well, there is the, any convenient during the next week, well, 36, well,
26.
not.
Lordship,
Obliged.
with regards to item 34, it's an AB matter, Lordship. Can the matter come up next week on Tuesday? There's no, we don't have interim, Lordship.
Okay, Tuesday.
34.